Seats. Thank you. Good evening, everyone, and welcome back to the continued set of hearings on the Coffin Butte application for expansion. On my way here, as probably many of you were listening to the radio, and I was just dismayed about the news coming in from Texas. And so perhaps we could begin just with a moment of silence for those suffering in Texas. Thank you. Begin with a roll call. Commissioner Biscoe, who I understand is participating online. We'll wait for her response to come in. Commissioner Cash.
Here.
Commissioner Fulford.
Here.
Commissioner Lee. Commissioner Struthers.
Here.
Commissioner Wilson.
Here.
Vice Chair Heyman.
Present.
I will note for the record, we have a valid quorum, and I presume Commissioner Biscoe has confirmed.
Commissioner Biscoe is here. Thank you, Chair Fowler.
Thank you very much, Commissioner Biscoe. We've got a full commission seated. Thank you very much for your participation. For those of you who have been following our progress on the application, you'll note that we have now come to the point where we need to make a decision on July 22nd. So that's 2 weeks from tonight, which means tonight we will focus on the revised staff report as well as the applicant presentation and perhaps get into some public testimony, but we will at a minimum do those two things, which we may be prepared for a longish evening. And then we will continue with public testimony tomorrow. I understand there are something on the order of 50 plus signed up so far. And so anyone can do the math at 3 minutes a person, and then with some questions. So tomorrow may also be a long evening because we absolutely must wrap up completion of the record by tomorrow evening, so that we can meet the deadlines associated with deliberating on July 22nd. And you also know that we begin the meeting with me getting to read some things into the record. So let us begin. This is the time and place for the continued public hearing in the matter of LU-24-027. The subject of this continued public hearing is an application for a conditional use permit to expand an existing landfill. The applicant is Republic Services, and the property owner is Valley Landfills. Oregon law requires that I make several preliminary announcements for this hearing. This is a continuation of the quasi-judicial hearings previously held on April 29th, May 1st, May 6th, and May 8th. And it will be conducted pursuant to Benton County Development Code sections 51.705 through 51.725. The purpose of the continued hearing is for persons to present and rebut new evidence, arguments, or testimony. In a quasi-judicial proceeding such as this, it is the Commission's duty to apply the law, not revise it. The Commission must determine whether the applicant has met all of the applicable criteria in the Benton County Development Code. The Commission will consider the record as presented and will also consider any new evidence or testimony that is submitted into the record. Please do not communicate verbally or in writing with any of the commissioners outside of this hearing process. A supplemental staff report has been prepared for the application, and the supplemental staff report was available 12 days before tonight's hearing. The supplemental staff report identifies the approval criteria that apply to the applicant's proposed development and analyzes those criteria. Testimony and evidence presented during these continued public hearings should be directed toward the new evidence included in or described or evaluated in the supplemental staff report. Any person may present or rebut any new written evidence, arguments, or testimony while the public record is open on the application. Any written materials received by the county staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the county staff in order to become part of the record. Except planning staff and applicant, no screen presentations are allowed. If a person intends oversized poster boards, reports, or pictures used in their oral testimony to be placed into the record, copies must be submitted to county staff while the record is open. If they are not given to staff, they will not be included in the record. Following the question to the Planning Commissioner, does any member of the Planning Commission wish to declare an ex parte contact? I see and hear none. I will now go through the hearing procedure for this evening. The procedure will be as follows. The supplemental staff report will be presented by the planners. I ask that the Planning Commissioners please hold your questions until the conclusion of the presentation. Then the Planning Commissioners will ask questions of the planning staff. The applicant will then present the case in support of the application. And again, the Planning Commissioners at the conclusion of the presentation may ask questions. And if time permits this evening, testimony from other persons in support of the application limited to 3 minutes. And if time permits, testimony from persons opposed to the application also limited to 3 minutes. And finally, the applicant may present rebuttal, which is limited to addressing any issues raised during testimony during these continued hearings. The commissioners may ask questions of the staff, the applicant, or persons providing testimony. However, the purpose of testimony is to provide information for the commissioners to consider. The public is not permitted to ask questions of the staff, the applicant, or the commissioners. Any person may request prior to the conclusion of the continued hearing that the record be left open for at least 7 days for the limited purpose of responding in writing to new written evidence submitted at this continued hearing. Following applicant's rebuttal, I will ask whether any person requests that the record be left open for that limited purpose of responding to new written evidence submitted at the continued hearing. Upon such a request, the Commission will determine whether new written evidence was submitted at the continued hearing, and if it concludes that it was, the Commission will leave the record open for 7 days for the limited purpose of responding to the new written evidence submitted at the continued hearing. If there is no request for an open record period, the record will be closed and the applicant will be entitled to submit final written argument prior to the Commission's deliberations. If you are a participant in this hearing, the Commission expects you to abide by the following rules. Please be respectful of all participants, both when you are speaking and when you are not. Speak only in the order of proceedings or when recognized by the chair. In testifying, please do not repeat previous testimony made at previous hearings. Be advised, the chair may halt testimony if it has become irrelevant, abusive, or clearly intended to harass or intimidate the participants in this hearing. Any written exhibits you want included into the record need to be handed to the Commission's recorder for marking before being presented to the Commission for consideration. Any multimedia presentations, any multimedia testimony is considered written testimony and should be submitted in the same manner as written testimony. All testimony and evidence must be directed toward an applicable criteria in the Benton County Development Code or other criteria which the person believes applies to the decision. Failure to raise an issue in this continued hearing accompanied by statements or evidence sufficient to afford the Commission an opportunity to respond precludes appeal to LUBA, the Land Use Board of Appeals, on that issue. The failure to raise constitutional or other issues relating to the proposed conditions of approval with sufficient specificity to allow the Commission to respond precludes any action for damages in circuit court. To have standing to appeal the decision of the Planning Commission, you must present oral or written testimony to the Planning Commission prior to the closing of the record. Verbal testimony is limited to 3 minutes total per person. Please respect these time limits so others have the opportunity to testify. The continued public hearing is now open, and we will begin with the revised staff report. And Winterbrook, you are up and ready to present.
Thank you, Chair and Planning Commissioners. Is the presentation working? Yes. Okay, I'll try to be close to the microphone. My name is Jesse Winterroad with Winterbrook Planning. We are brought in, as you may recall, by the county to provide a third-party review of the application and apply best practices to land use review for this. We also had MFA, Mal Foster Alonji Engineering, look at a great deal of the technical documents and provide their third-party review. We've worked closely with planning staff and your public works staff as well to prepare this document. And we can move forward. All right. So this slide shows basically the background, a lot of things that the chair mentioned. And we want to focus on the deadline for the final decision is September 26th, which is related to what the chair was saying about finishing in a next few days and weeks, because that time frame needs to include enough time for the Board of Commissioners in the event of an appeal to hold a hearing to evaluate that appeal. The slide shows we received quite a bit of additional information from the applicant June 6th, June 12th, June 16th, and June 23rd that we were able to incorporate into the staff report. As you may recall, the April 22nd staff report recommended denial on noise and odor, as well as missing some information to show compliance with the regulations. And that was our recommendation then. In the updated staff report, we looked at, as you recall, we talked about this a good deal. We were looking at the technical information only in the last staff report. The supplemental staff report brought in public information, public testimony, agency comments, evaluated in detail adjacent property testimony. So we had 14 adjacent properties. We brought in testimony from those properties. We also looked at 32 new or modified applicant exhibits that went into the supplemental staff report. And as you look through the staff report, you can see how all of these are brought into each criterion. And so it's significantly larger and brings in a lot more information than the previous staff report. Agency comments we received from Dogami, which was mostly no comments, but we received comments from ODF&W to talk about the heron rookeries. We received comments from NRAC, which we act as agency comments for this and prioritize those comments that recommended denial. We had comments from Adair Rural Fire District, which also recommended denial. And we had comments from Oregon Department of Transportation, which essentially didn't have comments on the application. We didn't receive responses from a number of other agencies that we request comment from, as shown here. Public comments, there were a lot. And county staff, I know, was working very hard to bring those in, catalog them, and present them. And there were over nearly 2,000, nearly 2,000 records received. We were reading a lot of comments and a lot of attachments. And I imagine that you were as well, commissioners. The major comments there, major themes, fairly similar to the previous staff report in terms of major themes: air quality, water quality, odor, some traffic, but mostly air and water, odor, litter, noise, methane, which goes into the air quality as well. So health impacts, air and water quality. Those are the major concerns that we are seeing in comments, and as this table graph shows. The supplemental staff report provides additional testimony, evidence, and staff responses for the impacts that we reviewed last time: noise, odor, traffic, visual impacts, water quality, groundwater, but also brings in 4 additional categories of impact. Litter, which had some very pertinent, relevant testimony, fire risk, wildlife, air quality, and we replaced groundwater with water quality as a more encompassing term. And so there's a lot more evidence, a lot more testimony, a lot more staff discussion on all of these items in the staff report. We have new findings that we put in for Goal 5 resources, where we thought there was enough testimony on wildlife impacts and how the heron rookeries work. And we looked closer in the code to address that. And so there's a new section on Goal 5 resources and Chapter 87. We had a lot more information on Chapter 53, Chapter 60, the Forest Conservation Zone, and 77, the landfill site zone. So there's a lot more information on all those sections that are highlighted here. Key findings, staff now recommends approval with conditions of the application. And as I mentioned before, if we were coming with conditions, there's a lot of them. And so we have over 80 conditions that we're recommending here that are related to each of the approval criteria. And we'll go through those. Starting off with conditional use, we talked about this in detail last time. Seriously interfere with adjacent property, with the character of the area, purpose of the zone. That's the standard. And so we dug into that serious interference standard. And for adjacent properties, we had, these are the properties. It's a map showing who has presented information in the adjacent area. And those were, I would say, elevated because of that adjacent property seriously interfere standard. Looking further out, this is the character of the area. It's about 90 square miles. And what this map shows is comments from the character of the area and beyond. As you can see, a good number of comments from Corvallis. And yeah, so there were quite a few comments in the area and beyond. But I mean, it's an interesting pattern of comments and worth looking at. But it just shows that there was a lot of interest according to southwest more down to Corvallis. And that's how it worked. Going into the noise impacts, this is where we had previously recommended denial because we couldn't see a path. What is a condition that would fix this? And we're not going to make things up like, well, build a 8-foot wall or a 20-foot wall. We don't know how that works. And so we said, you know, we have to recommend denial. The applicant came back with additional information relating to mitigation of noise impacts. And we had MFA look at this as well. A lot of new information, a lot of new analysis, a lot of evaluation of that. And would this condition work? Would these conditions actually mitigate the sound? What we determined, and we're relying heavily on our technical experts on this, is that we can condition this to reduce the noise impacts to a level that we feel would not seriously interfere with the uses on the adjacent property. We also had a number of concerns about, well, the bigger it is, you know, the more potential noise impact. And you'll see a lot of OP5 as an operational condition limiting the height of the landfill. And that impacts many impacts. If you limit the height, it will be less visible. It will be less likely to blow trash. There's so many impacts that relate to the height of the landfill. And so OP5 is an operational condition that limits the height of the landfill. OP2, A, and B are operational conditions related to noise. Odor is a very difficult impact to evaluate. As we talked about before, one of the things that we asked for was how do we even imagine this impact? What is it? What does 1 mean? What is 7? What does that even mean? What do these numbers mean? And this table was something that is in the staff report and shows, well, here is what those numbers generally mean. And One is sort of no odor to 7 being an ambient odor considered a nuisance, 4 sort of an ambient odor in a city, and then up to 1 million uncontrolled exhaust of a rendering plant, if you're right there. And so, so that was, I thought, very helpful to have that sort of visualization. What do these numbers mean? We received a lot of new information on odor, revised odor study, additional analysis of that odor study, and additional revisions and modeling. And I think even through yesterday, another visualization of the odor impacts. What that meant for us is, well, we again went back to MFA and said, does this odor modeling, I'm not an expert on odor modeling, but we do have experts on odor modeling as third-party reviewers for this application. And they pushed back quite a lot on the initial odor model. We got what we think is much stronger evidence-based analysis. And what it did was it showed there is odor noticeable at the property boundary of the landfill. And I think that is much more consistent with testimony, and the average odor of this is detectable at a landfill, as one might expect for a landfill. And so what we have been able to establish are a lot of conditions related to odor, as well as this average condition that we feel is technically adequate in terms of reviewing it, and shows where the odor might go and how much and what type of odor is being produced here. And so we have a lot of operational conditions of approval that we're recommending, that monitoring, logging, third-party review of their monitoring and logging, limits to working face, daily cover requirements, a lot of best practices, as well as the monitoring and reporting requirements. So with these conditions, we felt that this could actually mitigate the odor impacts with a reasonable evaluation of odor. We looked at transportation impacts. There were a good number of transportation comments, concerns about, are they evaluating the change in the Knife River and what's happening here? We were able to get a good amount of response from the applicant on that specific issue, the issues that NRAC raised, issues that public raised on this concern. And essentially, the applicant has evaluated those impacts on the traffic impact study. And what they're proposing seems to be consistent with meeting requirements for not seriously interfering with adjacent properties or the character of the area. So we have conditions that require them to do basically what they say they're doing, so that they can be consistent with the assumptions they used in their transportation model. Water quality. This is, if you haven't looked at the water quality section of the staff report, I'd recommend. There's a lot of information on that, a lot of testimony, both opponent testimony and applicant testimony and third-party reviewer testimony. It's a tough issue. Water quality, air quality are both. It's hard. It's a really hard issue. So the issue that we have here is the county doesn't really have the staff, the expertise, or the mandate or the resources to monitor air quality and monitor water quality for a landfill or for general industrial uses. What we do have is state and federal requirements to do those through agencies that are specifically mandated to monitor and enforce those requirements. And so what we have here are a lot of conditions that I think this is kind of the best we can do in terms of monitoring and making sure that the county can know what's happening. including things like groundwater sampling wells, installation and monitoring of those, monitoring adjacent property wells and arsenic levels, and then just compliance with local, state, and federal regulations and agency requirements. So that's what we're recommending on water quality. A lot of conditions, but ultimately, it's more of a state and federal issue to review and make sure that those are being controlled. Visual impacts is back onto fully within the county's purview. What we see here is the staff looked at what the applicant provided, and the applicant provided a number of elevation cross sections as well as renderings for the proposal. What we saw was understanding the height of the landfill is pretty important. 450 feet is not 450 feet from the ground level. It's 450 feet of mean elevation above sea level, which puts it well over 100 feet below the top of the existing landfill. So it's below the ridge line for Tampico and below the existing landfill by quite a lot. And in that visualization, it should be less visible than the existing landfill and shouldn't be notably visible from many directions. And so, yeah, you'll be able to see it, but from what we can tell from the application, it'll be less of an impact than the existing landfill and not rise to a level of significantly interfering with land uses and the character of the area. Litter impacts, again, conditions. We had some great testimony on litter that allowed us to dig into this. What's happening with litter at the landfill? What are they doing right now? How can they manage their litter better? And so we have quite a few conditions related to site management, litter management, additional fencing, additional cleanup areas on the west side as well as currently the east side. And with these conditions, and of course here again we have the limiting the elevation, which is applying to almost everything. It should be less impactful in terms of litter than the existing operation, and not be interfering with uses or the character of the area. The fire risk, we also had a good deal of testimony on that, as well as the Adair Fire District testimony that we were able to look at. We had an additional evaluation of their fire plan, and we had our expert engineers look at that fire risk again. And with these conditions, we feel that the applicant has provided enough technical expertise and testimony to show that they have fire under a reasonable amount of control. Things like a working fire truck on site is one of the conditions. Monitoring, logging, and making sure that those records are available relating to fires on site. Those are conditions that we feel are appropriate for this impact to mitigate. Air quality, we're back into what I was talking about before. How do we regulate air quality as a county? This is within the mandate of DEQ. It's in front of DEQ. We know they're evaluating it. And this is one of the things that state and federal regulations apply to. And the county really doesn't have the tools to grasp the how to evaluate and say what level is enough or too much of methane. How does a county figure that out? And so monitoring, requiring state and federal approval of what they do is, I think, what we can do for that impact. We also have, as I think hopefully people know, change in state law that we've noted in the staff report that applies to solid in municipal solid waste landfills in Benton County, which is this landfill, that will update DEQ regulations and monitor this situation. And so this is coming from the state, another level of oversight for this landfill in state law. So overall, we're looking at undue burden on public facilities, utilities, services, improvements. We looked at impacts on traffic, which we already talked about, leachate, groundwater, fire risk. Fire risk, we took another look at because we did have a good amount of testimony from the fire district on undue impact of burden. And so we have specific discussion of their comments. And part of that was also saying, if the fire district has additional conditions of approval related to fire management on this site, we would welcome those to see what those might be. But right now we have the concerns that we've addressed. We think that with these conditions that we've talked about before, they also work to limit burden on public facilities. Moving into the forest conservation zone. To be clear, this forest conservation zone deals with development in the forest conservation zone, and the landfill fill is within the landfill zone, the landfill siting zone, but some things like leachate ponds, employee buildings, and some driveways and such are within the FC zone. And so looking at those FC zone impacts versus accepted farm and forest practices around the property, there wasn't a lot of direct testimony on this specific item, like development in the FC zone versus the impacts created by that development. There's a lot of testimony on the landfill, what happens from the big pile of trash, but not a lot of direct testimony on this particular item. But we brought in, there are leachate ponds, there's discussion of leachate impacts and concerns. And so we have conditions of approval that we're recommending based on similar to the water quality, leachate management, and making sure that we're in compliance with state and federal regulations on leachate management in relation to this condition. And then we brought in a condition that is required in the FC zone, which is for fire breaks that will be required on any building in the FC zone. The applicant provided information on additional buildings within the FC zone that we had recommended. We didn't have the information on, so we couldn't recommend approval of those previously. Now we can see where they are and we can make findings on them. And what we see is the buildings seem to be placed in positions where they can have fire breaks, that they're not interfering with adjacent farm and forest practices. It's pretty straightforward. So we found that they actually do meet those standards now, and we no longer recommend that we don't have information. Goal 5 resources. We took a bit of a deeper dive into this, that basically here we have the heron rookeries. How do those get managed? We took a closer look at ODF&W. There's a lot of public testimony on the heron rookeries, and following ODF&W's, let's say, advice, they found that the applicant's approach was reasonable to protect the heron rookeries. We recommend conditions that protect the heron rookeries, active rookeries monitoring, identification of a 300-foot forest practices buffer, prohibiting construction during critical nesting period. So during construction, protection, and also during operation. So a set of conditions for both of those to ensure buffer and protection of heron rookeries. Development. So Chapter 99 is focused on building, if you're doing building permits or if you're doing land divisions. And neither of those are really what we're talking about right now. But one of the items that was raised by opposition was how are you dealing with the wetlands and how does that work? And what this condition P1, the first condition, requires approval from DSL of a wetland delineation prior to any ground disturbance on the site. So until they can get that, then they can't break ground. And so they'll have to go through that process in order to even start. And that leads to a recommendation of approval with at least 85 conditions related to all of these particular standards. And I tried to get through this pretty quickly so that we'd have time, but we have plenty of time now, I think, to take questions or if you'd like to move on to the applicant.
Very well, thank you. And I can speak for the rest of the commissioners that we very much appreciate the deep dives that you have done into the new information and especially the respect that you have shown to the public testimony and incorporated that into the report. Our process is we will afford each planning commissioner, beginning with Commissioner Bisco, the opportunity to ask questions. And at the end of each individual commissioner's time, we'll do a little round robin. And you can catch any and all questions that have come to mind, as this is our last opportunity to ask questions of the staff reports. We want to make sure we get all of those prepared. So with that, if we can turn on Commissioner Bisco's microphone, and Commissioner Bisco will turn the floor to you.
Thank you, Chair Fowler. Can you hear me?
Yes, we can.
Very good. I do not have any questions that are new for this additional information, but do wish to hold that round robin at the end for opportunity for questions that may come up in this additional questions from the commissioners.
Very well, thank you. Next, Commissioner Cash.
Right. Got it on. There we go. Sorry, I was pushing a different button, maybe. I don't know. So I didn't hear your name earlier. Was it Withrow?
It's Jesse Winterroad.
Winter Road. Thank you. Okay. What a delightful name. This is a question really just for my own understanding more than addressing the specific data in your, I agree, excellent report. Thank you very much. It was so easy to absorb even the unfamiliar topic. So there's these 84, I think you said, conditions, and that's a lot. And so they'll be monitoring, I assume, by various different agencies during that process. So then let's fast forward and this is in place. There's this new part of the landfill operational. What kind of monitoring and logging and this logging and recording and things that go on, what's the oversight on that? And I understand you don't need to be detailed. It's just, is this something that's internally monitored? Are they reporting to outside agencies? Are they?
They're reporting to the county as well.
Mm-hmm.
So, yeah. So part of what we wanted to accomplish with these conditions, and as you can see with the odor condition, especially noise condition, is monitoring, monthly reporting, I think annually reporting, but with odor especially, a third party that comes on site and also monitors odor with them to make sure that what the third party is sensing is similar to what they're actually monitoring and recording. And so, yeah, so that's the condition. What the county does with the information is up to the county.
Mm-hmm.
And so people can see it and evaluate it.
Mm-hmm.
Yeah. Sure.
Oh, take my finger off.
Commissioner Cash, any more questions?
I am done for now. Thank you.
Very much. Commissioner Fulford.
Thank you, Commissioner Fowler, Chair Fowler. Um, uh, As far as I do have a couple of questions. I'm really concerned about, I guess, the transparency. Will there be like a real-time compliance dashboard or public transparency portal made available to the public? It seems like we don't see these things, right? Or they go somewhere into a dark place, and we're not really. So a sort of extension of what Commissioner Cash was saying, can we see the data?
Yeah, it should be available. We don't have a process in place for all these enhancements that are recommended yet. But if they are adopted and move forward, then certainly we'll need to follow through logistically on making that information more available to folks. We have, as part of this process, added some accessibility features to our website, and we have a commitment for the department to continue along that path. We also have enhancements with the interaction with DSAC, and there's also a plan to reestablish the role of SWAC with the county. So there are plenty of enhancements down the road. We just don't know until we know what the final decision is.
Thank you. Second question, it's on water quality and air quality. One of the statements that was made was, we're going to rely on the state and the feds to help us out and keep oversight on it. And it says, well, the county's short-staffed, short resources, we got gaps. I'm a little confused. I would think Coffin Butte would be something, and the air and water in our community be very top. What's pushing that monitoring out of for Coffin Butte or just our community in general? What are the other priorities?
Priorities for the county or
For the county, yeah. It seems like we're in some sort of competition for resources, and this one's losing out.
Yeah, so that would need to be a question for the Board of Commissioners in terms of the prioritization for where we put our enhancements, monitoring, and resources. So that is a policy decision outside of the land use process.
And what is, I mean, you know what's going on. What's top right now? What are the top couple of things we're spending our resources on?
In compliance,
Mm-hmm.
well, we have just hired a new compliance officer after having that position was vacant for 3 years. So we have a backlog and 15 current code compliance cases that we're catching up on, which is great. We've also put some resources into new software for short-term rental monitoring, and that's a collaboration with the assessment department so that we can look at not only the value of those properties, but whether or not that they're in compliance. So that's another investment that's been made on compliance. We have a position that's vacant that we plan on creating in the next 2 years in community development in a water quality coordinator. So we do plan on moving forward with that investment. So that's yet to happen, but we do have approval from the board to create that. And then, of course, you are familiar with our solid waste management and regional efforts there. And we've gained a lot of momentum with that regional effort. And there is a financial commitment by the board to continue with those efforts, including federal funding that's, or excuse me, state funding that has now been long-term funding to support a position for outreach and compliance contribution on solid waste. So there are resources, but not a formalized work program to work on enhancements from our current level of service in those areas.
All right, thank you. Chair Fowler.
Thank you very much, Commissioner Fulford. Commissioner Lee.
Thank you, Chair Fowler. I have several questions. On page 55 of the staff report, I'm going to turn there myself. There's a statement in the applicant response that says, it's about the middle of the page. Last sentence of the paragraph says, typically, construction activity to cite a proposed use is not considered part of the impact for conditional use review. Is that the opinion of the county? In other words, is construction activity going to be considered as part of the impact of this conditional use permit?
Yeah, certain elements, particularly excavation and the impact to the subterranean environment.
So not noise and not the groundwater.
Yeah, subterranean, so underwater, groundwater, and their noise, vibration impacts.
Okay. Page 67 discusses litter. I'm wondering, are there any conditions of approval in the existing land use permit for litter? What are they? Not for this new proposal, but the existing permit. Are there conditions of approval related to litter in the existing permit?
In the, off the top of my head, I don't have the wording for the litter plan. That would be a good question for the applicant on what their litter plan is.
Okay, page 83 is a discussion of odor as it relates to tonnage of organic matter. And this is, my question is, does that replace a tonnage cap? Or how does this relate to a tonnage cap?
This is directly related to the applicant's submission of impacts. And in their odor evaluation, they assigned a number of tons per year over a certain time frame that we said that is the amount of impact that they are allowed to create through landfill filling. So it is not technically a tonnage cap, but it is directly related to the amount of tons of trash that are submitted and their odor study.
That doesn't answer my question very well. I'm sorry, this is very confusing. Can you do better?
Well, the tonnage cap is something that the applicant has come to an agreement with at the county board level. This is a condition related to impact of odor, which limits the amount of trash deposited on the site per year in a volume of tonnage. So they're very, very similar, but they are not the same because we are not regulating a tonnage cap.
Hmm. Okay, maybe.
I can try to step in.
Yep.
Jesse, that was a great explanation. And Commissioner Lee, I'll repeat what Jesse said. The franchise agreement between the county and the applicant imposes a tonnage cap right now. The tonnage cap apparently under the franchise agreement goes away if an expansion is approved. However, all of the applicant's studies that were submitted to demonstrate compliance with all of the criteria rely on assumptions of waste that do not exceed something like 930,000 tons. If the applicant's submissions had not included those assumptions, then the planning commission could have potentially concluded that the applicant had not made the demonstration that this criteria were satisfied. So essentially, the planning staff decided to hold the applicant to the assumptions in their models in order to find that odor and noise, for just odor mainly, that odor will not seriously interfere with uses on the adjacent properties. So they are different. They are related, but they are different.
So see if I understand a little bit. There's a lot of modeling that's done mathematically to accommodate this permit. And you said most of them assume an annual tonnage rate that's equal to or less than this number, 900,000-ish. Are there other models that are used in this permit application that are not limited by that number? In other words, that do show a growth over time of the tonnage. It's the annual tonnage rate.
No.
No.
Okay. Okay. Thank you. Page 88 talks about the purpose of the zone, and it uses the term buffer properties, and I'm wondering, are buffer properties required? What's the status of buffer properties as it relates to the landfill and the forest conservation zone, the landfill zone and the forest conservation zone?
Sorry, page 88.
Page 88 and 89, purpose of the zone. On 89, I see the term, note also that the landfill buffers are not a by right use in the forest conservation zone and are not allowed at all in rural residential zoning district. I just would like to understand buffer properties. Are they required? What's
So-
the status of buffer properties?
Yeah, to be clear, this is opponent testimony and not referencing code standards here.
That on that page, yes.
Yeah.
Let's see.
So I don't know how to respond in relation to the code if that's not a code requirement.
Okay, it's not a code requirement. I guess that answers my question. Page 106 and 110 both mention setbacks. In my experience in my community, forest conservation zone requires a 300-foot setback. So I need to be corrected if I'm wrong, if that does not apply here.
Which page?
Page 106, I think. It says, on 106, kind of past the middle of the page, non-residential structures shall be located at least 20 feet from a parcel or lot line,
Mhm.
except no setback is required for a structure, a small structure, blah, blah, blah.
Right.
Now, so I'm just remembering the issue of setbacks in my community, and that when forest conservation property abuts other uses, a 300-foot setback was required in an instance. And so I'm wondering when the 300-foot setback, how that fits into this application.
Well, we can look into that and try to figure out what you're referring to.
Okay.
Yeah.
Page 117. Top of the page, findings. So this is in a discussion of Chapter 77 requirements. This is the landfill chapter. And for the conditional use permit application shall contain a reclamation plan, and it shall contain the following environmental and operational conditions shall be reviewed prior to changes in the documents referenced above: geology, groundwater and surface water, soil depth and classification, slope, and cover material availability, transportation, and use. The finding is that BCC 77.310 parentheses 4 only applies to changes to a site plan map and reclamation plan. The proposal provides a new site plan and reclamation plan. Therefore, BCC 77.310 does not apply. So in other parts of this application, the application relies on this not being a new site, it's an update. And in this case, it's saying this is an update, not a new site. Anyway, it's all confusing. Please explain.
Sure. Yeah. So this criterion is if you're changing something that's already been approved.
And we are.
We are going through an entirely new application process. And so that evaluates these same items through the new process.
We did not discuss cover material availability, transportation, and use.
You're right.
Okay. That's my questions. Thank you.
Thank you, Commissioner Lee. Commissioner Struthers.
Thank you, Chair. I originally had one question, but as we were going through your presentation and some of the other questions, I came up with a couple more questions. So I will be quick, I hope. My first question essentially was answered, I believe, at the beginning of your presentations on slide 4. I'll summarize what the slide was. It was about the April 22nd staff report recommendation. And it was sort of in line with what I was trying to do, because when I saw the supplemental staff report come out, it went from a recommended denial to recommended approval. I'm like, okay, what's changed? You summarized it here. My understanding between the two reports and through this whole process, these were the only specific reasons for the denial. Is that correct?
For the first staff report.
Yes, for the first staff report. Okay. Or at least from the recommended denial, these were the specific reasons why.
Right. And as you recall, the first staff report was looking at technical evaluation of the applicant's submission. It didn't include the other testimony. If there had been inclusion of the other testimony with what we knew at the time of that staff report, there might have been additional items that we recommended not, because there are additional items that the applicant needed to supplement their staff report to address. The 32 additional exhibits that they provided to address public testimony and agency testimony that came in.
My next question, related to conditions of approval, they are meant to mitigate concerns or issues. They are not to fully eliminate, or not always meant to fully eliminate issues and concerns. So I help to mitigate those, correct?
Mitigate to the level that would meet the code standard.
Okay.
Yeah.
And I'm summarizing public comment here. I'm not throwing my own words into this, but in the public comments, there was reference that the applicant at times has not been fully compliant with past conditions of approval. Is that something that this body is allowed to consider as part of the review of this application, or because that's a separate permit, a separate process, we can only focus, the code only allows us to focus on what's in front of us to date?
That's the way we look at it. We can defer to what our counsel has to say about that as well.
Bryce, thanks. On the spot again. This proceeding is an application for a new conditional use permit, the planning commission is, any decision maker is always allowed to judge the credibility of the evidence submitted. But in order to call that credibility into question, it's important to have equally strong or equal level evidence to call that credibility into question. I guess that's a way of saying sort of.
Or another way, say it being, it depends.
Also, it depends. But
Okay.
generally, the planning commission should focus on whether the application meets the applicable criteria, you know, with or without conditions, and it's the county's obligation to monitor the conditions, and there is a legal process for enforcing the conditions should the county have the budget to do so.
Okay. Okay. Petra, did you want to say something? I have one more question.
Yeah, no, I agree with what's said there. And trying to track down with the limited history that I've had on that particular concern that the public's had on the conditions is that that particular question wasn't formally adjudicated in any way to this point. So until it is, we don't have any evidence that indeed those conditions were not followed. So there are two sides to that story. There's a very limited written evidence in either way. So there has been due diligence in terms of trying to track down the history of those situations, and they just haven't been fully vetted yet. So it's hard to rely on that anecdotal information is essentially the status from our perspective at this time.
And then my last question, and I apologize if I'm mixing multiple conversations because it's been a while since we've been here in a hearing on the conditionals of approval because they're in front of us now. What level are we allowed to include any type of penalties related to for compliance, or is that, say, a county level decision, not a planning commission level? And if I remember right, and this is where my memory is a little foggy on this, did we have a very quick, brief discussion about a bond or bond, like some type of bond related to conditions of approval? And can we get a quick summary of what that would look like if something like this was to move forward?
I think it'd be appropriate to have the legal counsel respond to that specific question.
I can't respond to that yet, but I'll take a look through the code and see if there's any vision for requiring a bond. But
Again, I don't remember if it was this hearing or if it was another conversation related to something, but my question related to the penalties, is that something that could be part of these conditions of approval?
financial penalties?
Yes.
Probably not.
Okay.
Thanks, Commissioner Struthers. Commissioner Wilson.
Thank you. And I want to commend my fellow commissioners and the chair. Thank you, Chair. They've asked a lot of probing and good questions. And so my last one and only question that I have is that it is a lot of conditions of approval. And so when we look at, especially in your presentation, and I don't know which slide, but it's the one where the conditions of approval are broken into phase 1, phase 2, and then conditions of operating of approval, COAs. My question is, phase 1 and phase 2 have to occur before the applicant can proceed into the conditions of operating approval for the landfill expansion. Who determines whether they've met the criteria or are meeting the criteria for phases 1 and phase 2? And I think a nod to Commissioner Struthers, what are the coercive mechanisms that the county can use in order to either, put them into compliance on those conditions of approval or suspending the proceeding of work, or if it can be suspended on that basis.
Yeah, so there's timeframes for meeting conditions of approval prior to construction, but the next phase will be to go towards design. So when they're ready to go towards design, it'll be a check as part of the design process, and Public Works reviewing the design will mean that they need to have met all of those conditions of approval from the planning department. So there'll be no review from Public Works unless planning has signed off that all the conditions have been met at that phase. Then that process is reiterated when you go to construction. All of the conditions of Public Works on the design process need to be met prior to construction. And then there's an inspection process during construction, and then there'll be a monitoring process for the operating conditions.
And I guess that leads into the question of who does the monitoring?
So that'll be from different directions, right? So the operational conditions are actually self-imposed. So those were presented by, or those were suggested by the applicant. So those are operational, because land use generally is not going to delve into the operational conditions, but that is something that they wanted to make sure was a commitment that they put into this process. So Jesse talked about the different state agencies that are responsible for the different elements, water, et cetera. So they are responsible for that. What we're wanting an enhancement on, understanding the collective frustration on the state monitoring process, is additional transparency, additional reporting, additional eyes, so that we can put pressure on the state agencies to pay attention with more rigor to this particular site and the impact that it has moving forward.
Great. Thank you, Chair Fowler.
Thank you, Commissioner Wilson. Vice Chair Heyman.
Thank you, Chair Fowler. I think I only have one question, but it might be, I need help on this. Okay. I think this was a concern I had the first time around, and then with this updated application, things have become more either concerning or confusing. So I want to ask a question. It is my understanding that existing conditions cannot be used as a reason for either approving or disapproving the application. And I think as I read through especially the testimony public, there's a lot of reference to this existing conditions. And it would seem to me logical, at least using extrapolations, to say that whatever existing conditions there are, the approval of this permit could exacerbate those conditions. And that would be a reason for denial, I think. You have changed your recommendation, which I have to assume, and I'd like clarification, that you do not believe that the approval of this permit would increase whatever negative or whatever existing conditions that have been so much a part of this conversation. Because each one of us is going to have to make a decision, and I'm trying to clarify what is a new condition, what is not a new condition, so I know what I can consider and not consider. And if you could give me some clarification on that, I'd be really, really grateful.
Right. Well, I think you did hit the issue right there. If it is making things worse, then that's definitely something that you can consider. Does that seriously interfere with adjacent land uses? If it's making things that, and it's not necessarily just that delta of change. It's will the total situation here be seriously interfering, including the existing landfill and the new one. What's happening here is a transition from the existing to the new one, and the new landfill is shorter, more constrained by topography, will have a lot more conditions that relate to litter management, will have more modern facilities related to leachate control, related to air quality. So it's different facility, and the analysis that we have that has been reviewed by third-party engineers indicates that ultimately it's a lower impact than the existing facility. So that's sort of the basis of our conclusion. With these conditions of approval, we feel that it doesn't increase impacts to the point of seriously interfering. In fact, it mostly decreases from existing conditions.
One follow-up questions. The new conditions only apply to the new part of the landfill and not to the old part of it. So it
That's
doesn't have any positive or negative impact to
Correct.
the existing landfill.
Right. So we do have a condition that limits the landfill expansion to south of the road. So, yeah.
Thank you. Thank you.
If I may, we do have a couple answers to Commissioner Lee's questions.
Please.
Before we lose those, the first, the 300-foot setback is dwellings, and we don't have any proposed dwellings here. And the other item was the past conditions of approval, and we didn't look at every condition that has happened in the last 50 years, but we did look at the previous conditions most recently, and we didn't see conditions related to litter. So these would be new imposed conditions that are greater than what they're currently doing on the existing site as well.
So I just have a couple of questions, and we'll throw it open for roundtable to conclude this section. I think everyone has identified the externalities of odor, noise, and potential water issues as those just rise to the surface, and it's frustrating that there are overlapping jurisdictions with all of those as well. We don't have DEQ here to ask any questions, so we don't know what their plans are. But as I look at all of our conditions that are contained within the 85 or so proposed conditions, many of them either relate to or rely upon the state to do their job. And we've already heard in testimony that noise is no longer enforced by the state. It's just not enforced. We've heard public testimony that DEQ is unresponsive to odor complaints. And with respect to water, there were less specific incidents of lack of response from the state, but it strikes me that when a responsible party is not living up to their portion of the burden, is that not an undue burden if they do not have the resources to do what has been asked of them? And can this body place a condition of approval that appropriate resources are in the state monitoring organization, or else the project doesn't move forward because it would be an undue burden?
That's a really interesting question. I appreciate that question because it's a good way, a new way of looking at things. And so we have the state legislature putting additional burdens on DEQ, and if DEQ can't do what the state is telling it to do, if DEQ can't do its fundamental job, that's a situation that's kind of beyond the county. I don't even know how we function in a situation where we can't rely on other agencies to do their mandated job. How do we make a decision with that? situation.
Ms. Ryan, do you have any opinion on this?
Agree, it's an interesting question, Jesse. I guess my opinion is, I think the criterion that you're getting at is it an undue burden on public facilities? And I think what I heard you say is, it may be an undue burden on public facilities if the state, the federal government, other enforcement entities don't do their jobs. But it seems to me, I guess my answer is the same as to Commissioner Struthers. In order to discount the evidence in the record that in fact, as the staff has concluded, the application won't place an undue burden on public facilities, there has to be somewhat equal evidence that it will. And that there's no evidence in the record really that the state, other than that the state does not, DEQ no longer has the budget to enforce noise levels, right? So it goes back to an evidentiary question. I think it would be difficult to put a condition of approval in, such as the one you suggest. But we can think about it. We can think about it during the applicant's presentation.
I would appreciate that.
Yeah.
On the odor topic, I think I understand the model and the proposed condition, which suggests an organic waste limit, which so that would suggest that we know the composition of the solid waste going into the landfill. Did you test that assumption? Do we know the composition going into the landfill today?
Currently, the applicant, as I understand it, tracks the composition of waste. But I think that's a great question for the applicant.
And I will also ask it of them, but that would also suggest that with that assumption and knowledge of today's volume going into the landfill, we could actually confirm the model based on measurements. If you know the inputs, you know the assumption, you know the outputs based on measurements, you should be able to confirm the model. Is there anything in the evidence that has confirmed this model?
For odor?
For odor.
I think that's a good question to ask our odor third-party reviewers or online.
And is that something that they could look at as we go into the round robin? Oh, and are they prepared to answer now?
So
Sure. Hi, I'm Ellery Howard with Malt Foster. The model contemplated 930,000 roughly tons per year of organic waste, and that does fall in line with what has been reported by the annual reports that the applicant submits to the state. So that's where that number came from. That is a 2023 number. Hopefully that helps. Chad, I'm not sure if you have anything further that you want to add.
No, that's correct.
So that speaks to the total volume, but if you know the inputs and the assumptions and we're measuring odor, we should be able to confirm that the model is accurate.
That is correct. And that 930 is if you look at the past few years, that has historically kind of bounced around that number as well. However, they do accept inert waste. So, and that would be considered inorganic and not creating an odor. Things like concrete and construction debris like that.
Understand, but with those figures, we should then be able to correlate to the DT figure that jump out of the model. Have you seen that correlation? Has that correlation been done, and is the model been confirmed? Do we have confidence that by limiting the amount of organic waste, we are going to achieve the DT that is predicted by the model? And it seems you confirm that if we understand all the inputs with today's operation, because today's operation is essentially the precursor to tomorrow's operation.
Sure, and I'll let Chad, as the odor expert, speak to this a little bit. But what we asked the applicant's consultant to do was use the actual emissions from that 2023, and so that is what that is based on. So it's not based on an assumed emission rate. It is based on actual emissions, and that was based on that same year of the 930,000 tons. So Chad, go ahead and fill in from there.
Yeah, it's a great question. And what I can say is that we had the applicant go back and add a significant amount of realism to the model, including actual emissions and throughputs. The biggest evidence we have that the model is tracking appropriately at this point is that the model now shows that there are at times levels of odor that would be above detectable levels. Not to the level of nuisance, future looking, but certainly above the 1 D/T threshold at which you would smell something. And that correlates well with what we're seeing from input from the community in terms of noticing odor and reporting it. Previous iterations of the model showed significantly below 1 D/T. We didn't feel that reflected reality. We did request the applicant to go back and remove some of the the elevations that they were using in the model, and to have it reflect closer to ground level releases. Models are not great at modeling surfaces that have complex topography. And so one of the things we asked the applicant to do to add realism was to go back and to carve the landfill up. And I think they chose 63 different squares. Each of those squares were placed at the midpoint of the height of the landfill where they were located in the model. So the model now reflects the complex topography, and that's leading to us showing that there are times when odor will be noticeable. So there isn't, models are not like this, are not such that you could say, well, it models tomorrow that the odor will be this. Let's go measure it and see what the waste placement rate was. Yes, that tracks, the model tracks perfectly with what we actually measured. But the model used AirMod has been calibrated by the EPA historically to make sure that it's reading relatively accurately with what you would expect downwind using monitors based on what's being emitted upwind. And we're seeing in this model that the applicant has submitted improvements in the realism of the emission rates using actual waste placement and reported values, and improved accuracy in the way that the model describes the landfill topography. And so we do have confidence that the results now are tracking with the observations of the community.
Thank you. I'll also look forward to the applicants addressing of these same topics. And with that, I'll throw it open to round robin to catch any questions. Commissioner Struthers?
I can go back and watch the video from April 29th again. I just want to try asking my question again, because while we were waiting here, I went back and looked through my notes. And that was actually Chair Fowler who was asking questions that night. And I didn't do a very good job, maybe because it was getting late, of the actual note that I have here. But what I have in my notes is a bond requirement for conditions of approval. And I can go back and watch the video again and see what that discussion was. But I wasn't sure if that's ringing a bell of any type of what happened at, we had a very brief discussion on that. And again, I can go back and watch the video and get and watch that, but it was something that apparently came up.
There's nothing in the code that allows for that type of a condition. It would also be difficult. So to recover on the bond, there would need to be a formal proceeding in which the applicant and others could participate in a formal determination that a condition is not being met before the bond could be executed on, if such a thing existed.
Okay, and that's probably what somebody said that night on the 29th, but it's been a little over 2 months. So
Yes.
It's just, I knew there was something in my head that there was a very brief discussion about a bond. So I think that's probably what was discussed on the 29th. So thank you.
Other questions from the commission? Commissioner Fulford.
Thanks, Chair Fowler. Quick question. In the initial application, I read it was a 6-year, it's sort of a scope question, right? Timeline. That we were adding 6 additional years to Coffin Butte's a workout at Coffin Butte, right? So, but now I'm reading it's 2052. Are we talking about 6 years? Or are we talking about 27?
The applicant's odor study looked out to the year 2052 with that assumption of waste annually.
Thank you.
Commissioner Wilson.
Thank you, Chair Fowler. Again, another odor question, and it's just because I'm not a scientist. Not all emissions have odors, but some emissions are still harmful. And how did you address that? Because I can look at the chart here, but I can't tell which ones won't necessarily have an emissions odor that would tell me that, oh, I'm smelling X chemical, if you know what I mean.
Right. So odor is a typical impact that the county reviews and is very common in terms of conditional uses. Where we look at potential health impacts is in air quality and water quality. And those are where we have a number of conditions, but ultimately it's review from DEQ and the EPA on how do you evaluate what is an appropriate level of chemicals as harmful. You know, all of those are established not by the county, but by other agencies.
Okay, thank you. Thank you, Chair Fowler.
Commissioner Lee.
Thank you. On page 145 at the top of the operational conditions of approval, it states monitoring of operational COAs will be subject to BCC Title 31 enforcement. I read through that very quickly. It mentions a $25 fine, but I missed a point that I would like to have someone try to explain, and is what would initiate a, this was talking about how hearings and things, how an issue would come before the county and receive a $25 fine. What would initiate that?
Yeah. This is another example of antiquated code that we have, and our intention is within the next 2 years is to modernize it. So by the time, if this is approved, and by the time we get to construction, it'll be a completely different enforcement process. So I'd just like to start with that. But currently, the enforcement process is initiated by either a compliance officer becoming aware of it, or someone out in the field, or somebody, a citizen bringing a complaint to the community development department, and then it's looked into. And if it's substantiated, then the officer will follow through on compliance. And generally, our approach is that we try for a voluntary compliance first prior to going through that process. But that is a final process if we're not able to get through the the first 2 to 3 efforts at voluntary compliance.
Thank you. So that brings up another question. If the code changes in 2 or 3 years, would this application be subject to that? Or can changes like that impact an existing approved permit?
So the enforcement process, by the time this project has been built, the changes will have been made to the enforcement process. So are you asking if it would be grandfathered in with the current process if this is approved now? Is that what you're asking?
I'm asking if the code changes, would this application be subject to those code changes?
Yes.
Thank you.
Let me check in with Commissioner Bisco. You had asked to reserve potentially questions at the end of the round robin. Commissioner Bisco, any questions?
Yes, thank you, Chair Fowler. Can you hear me?
Yes.
Great. A couple questions have come up just through the conversations. Thank you to my fellow commissioners for bringing some good questions forward. I do have a couple based on some of the information that we've now talked about. Back to the modeling of the assumption of the 934,000 tons of, I believe it's organic waste. Have we done any modeling that considers not what has happened in the past, but what could happen with the lifting of a tonnage cap, related to how that would impact modeling if we increase the amount of waste that we bring into this location?
Thank you for asking that. The answer to that is no, they did not evaluate increased tonnage above the 930,000, which is why we imposed or recommending imposing condition of approval that limits that waste.
And to be clear, that waste was organic material and that's related to odor specifically. Did I understand that correctly?
Yes.
Okay. Thank you for that question. Also with the changing in the conditions where we have proposed a limit of, it's the new height limit of the expansion. It's 400. Could you clarify that number again? The 400 and some odd feet?
Yeah, 450 feet above mean sea
400
level.
Above, okay, above sea level.
Right.
Could you remind me the above sea level height of the current landfill just for proportionality?
So that the current landfill, I believe, is over 600 feet.
Okay, but we don't have an exact on that presently.
They did submit an exhibit that shows the elevation and cross section of the current, and it's approximately 170 feet above the proposed 450 feet.
Okay. And then with that, and this may go to Commissioner Fulford's question, how will that new limit of 450 feet above sea level impact the longevity of the use of this landfill? I understand that we have an odor, assumption that's going out to 20, I think it was 52 you said, but how will this new limit influence the longevity of the use of this expansion?
I think it depends on the amount of waste that's coming in, and if they have less than 930, it'll limit the impacts of the use by imposing a height limit. If they run out of space at 450 feet, then they can't go above it.
I think that's a very appropriate question of the applicant.
Right. Okay. Thank you. Then also, I'm going to go back to some staffing, some of the comments that you made in the presentation, and then also in the follow-up. We talked about water quality, for example, being the purview of state and federal regulatory agencies that we rely on at the county. But I also hear that we're bringing on a water quality staff position, if I understood correctly, at Benton County. What will that person's role be if it wouldn't be in any way related to or, touching the land landfill space. I'm struggling, I guess, with we're not permitted to, and yet we're providing a position at Benton County related to water quality. What's the distinction here why they would not be involved in any of the landfill water quality subjects?
Yeah, it's not that we're not permitted to. First, there is an option for us to, again, be more rigorous if we have the resources. The water quality coordinator position is currently focused on, a current body of work defined, and the focus is on total maximum daily load requirements. And that's the stormwater, so TMDL. I won't go into the details on that. So that's water quality permitting, state permitting requirements that the county is responsible for in unincorporated areas. So that's a regulatory a program that we're required to participate in with the Department of Environmental Quality. So that's the impetus for the position, because we don't have someone on staff at this time that's able to do that work. And then there's also a number of partnerships with Public Works and parks around stormwater, riparian restoration, things of that nature, for that position. It's not to say that it couldn't expand the role and responsibilities specifically to water quality issues if a county policy made that so and pivoted some resources towards the landfill. That's certainly an option. But that's above my station.
Okay, and that's really helpful. I appreciate that. I'm going to go back to what was previously presented by the county, was that at this time, there's no plan then to have any staffing related to compliance related to the landfill, no position, no funding or resourcing. Is that still correct then?
Not at this moment in time, but it's
Meaning at this time, there's no plan for that position or resourcing, or I'm incorrect and not at this time?
that's correct. There is not a plan for that at this time, at this moment in time, but that's not to say that there's not potential for that in the future.
Okay. One of the questions that I'm hoping to get answered still is the Benton County. My understanding is, and I think it's come up in this space, I'm not sure that I have that confirmed though in my reading, is that Benton County is guaranteed a certain landfill capacity for Benton County waste. Has that been confirmed by staff yet at this point? That came up before, but again, not sure if that answer has come to us yet.
Could you rephrase the question, please?
Sure. So it may be in the franchise agreement. I'm not sure where it lands, but Benton County, as a as a county with its agreements, and I'll use that small a agreements because I'm not sure where it lands, is guaranteed a certain. It's guaranteed landfill resourcing, if you will. Meaning the landfill can't fill and close for a certain amount of years. Was there not a year attached to that Benton County was guaranteed waste resourcing at Coffin Butte?
Yeah, thank you. That is that information is in the franchise agreement.
Okay, and do we not know that without looking that up again?
I'm sorry, I
I
don't.
believe that it's 75,000 tons.
Okay, and for a period of time?
Not sure about that.
Okay, is it possible that that answer can be confirmed by staff by tomorrow? I know I can go look for it, but I want to make sure that I'm hearing correctly from those of you in the room who are the experts. Can we have that by tomorrow?
No problem.
Oh, I'm sorry, I did not quite hear you.
No problem.
Okay, thank you. Let's see here, just a couple notes, just make sure no more questions. Okay, we talked about third party, and I've heard him a couple different times. I think I generally know which third parties we're talking about. DEQ and EPA are part of that third party. When we were discussing the odor and odor mitigation, it almost sounded to me as if we would have a third party that wasn't maybe DEQ or EPA. Is that correct? I see head nodding, but can you expand on who that third party might be? And then where is the staffing and funding for that person, or where will that person land within this process?
That is. It's a condition of approval that the applicant must pay for and contract that third party for that review.
Okay, and the oversight of Benton County in that responsibility, I understand the condition oversight and kind of where that lands. But in the case of, how do we select that third party? And I think it was Commissioner Fulford again that mentioned like a dashboard or that transparency. Is there more clarity on that component of this? Because odor and how it was presented in the last application is very different than now it is being presented. But clearly, based on testimony, it is a concern. So to help the planning commission understand, what does that condition of approval really kind of mean? Do we have any better idea of what that third party person and or oversight from the county might look like?
That's something that the condition is not final. And if the planning commission wanted to orient that condition more toward a specific outcome or result, then that's possible. These are our recommended conditions, and you will theoretically deliberate and discuss hopefully all of them, because I think you'll have to read all of them. And this is one, if there's a different approach to achieve the result that you're looking for in terms of monitoring and reporting requirements, those things are we're recommending, but it's up to you to have that final condition, and you can certainly modify the conditions.
And that's helpful. Thank you very much. Question on the transportation. It sounds like ODOT did not weigh in with an opinion. Were there other third parties outside of the applicant's traffic analysis and such that were participant to our transportation and traffic related data related to this application?
Yeah, we had on the county team a third party contract transportation engineer.
Okay. Contracted, and that was a transportation engineer, you said? Oh, was that a yes?
That's correct.
Okay, very good. Another comment was made about the Adair Village. If there was opportunity and Adair Village wanted to recommend conditions of approval, were they invited actually to consider submitting conditions of approval? It sounded like that might have happened, but I'm wondering if we did in fact ask for their opinion, being they're our first line of defense fire district.
Right. They were notified of the application, asked for their feedback and recommendation.
So feedback, recommendation, and conditions, or just feedback and recommendation as far as approval?
Yeah, they could provide suggested conditions that would be unique for a municipality to do that. But yes, we asked them twice to provide comment.
Okay, that helps clarify that. And then I think I just have one more. So sorry, some's in my type notes and some's in my written. So one last to check. I've gotten most of them. I have just one more section to check here. Lots of notes tonight, lots of testimony. So thank you for all of the staff information. It looks like that's all the questions I have as a wrap up. Thank you very much. I appreciate staff and those of you that are providing testimony as well this evening.
Thank you all for your thoughtful questions. We appreciate it very much.
Not quite done.
Dang.
Commissioner Cash.
Oh, sorry.
Thank you, Commissioner Fowler. Mr. Winterroad, you just said a few minutes ago, you said we could modify something. Could you tell me who we is?
I meant you, as in the planning commission.
Thank you for clarifying that. So I'm trying to track carefully the limit of what we're supposed to consider in making our decision as a planning commissioner. So I want to just touch on some points that were brought up this evening. We're not to consider prior non-compliance without evidence. No evidence is being gathered because oversight agencies are not performing those services anymore. Am I headed down the right road here?
You can
Yes, I would say no oversight evidence has been gathered because no formal adjudication of non-compliance with the current conditions has been done. A formal adjudication of non-compliance would involve due process and giving the applicant a chance to respond to the allegations. As I understand the evidence in the record, there's a lot of anecdotal testimony and potentially evidence that allege current noncompliance, but it has not risen to the level where due process has been afforded.
Thank you for that clarification. That was exactly what I meant to say.
Commissioner Struthers.
This will be my last question, and it's just a follow-up to Commissioner Lee. Thank you, Commissioner Lee, for finding on page 145 that little line there that talked about the monitoring within BCC Title 31. And I want to go back to the answer that was given. The reason why this application wouldn't be subject is because that is county code and not development
land use code. Exactly.
Not land use code.
Correct.
I just want to make sure from a process standpoint, that's why they're separate.
There's no goalpost issue.
Perfect.
Correct.
That's what I wanted to hear. Thank you.
I see no hands raised. And so that concludes our questions, and it is time for a break, I think. And we will resume at 8 o'clock with the applicant supplemental presentation. Everyone can take. Very well. We'll move into the applicant presentation. And Mr. Condit, or Mr. Roop.
Yeah. Good evening. And I want to make sure we get our presentation up first here. What I'm going to be talking to is not actually to that. So maybe we could go ahead and get started. So first, Chairman and Commissioners, thank you for this time. We appreciate the opportunity to talk in front of you again. And as a reminder, my name is Brian Roop. I'm with Republic Services, and I'll take a minute to introduce our team. I know we'll make sure and reintroduce as we go around because there's a few people, but just to call the folks out that are here. So we have 3 other folks from our internal team, Brett Davis, our general manager, and then 2 folks from our environmental team, both Brent Lurch, who works at our area office, and then Paul Koster. And maybe if you guys could raise your hands as I call your names. Paul Koster is our EM and associated with the Coffin Butte site specifically. Stephanie James, so then we have a number of outside consultants too. So Stephanie James is from Turnstone Environmental. She's been helping us with wildlife. A few folks from SCS, which is a consulting group. Jim Walsh is going to help us talk through fire tonight. And then Ray Huff and Greg Hauser are both here on odor and to present and talk through what we've done differently since the last application. In addition, we have Adam Jenkins here from Greenbush. He's going to be talking to noise. Finally, we have Jeff Shepard, who is from CEC. He's been kind of our overall project engineer and has a couple parts where he'll talk to. And then lastly, Jeff Condit, our land use attorney, will be helping us and frankly, kind of guiding some of the conversation tonight.
Very well.
So with that, on behalf of Republic Services, I just want to express our sincere appreciation to Benton County, the staff, the Planning Commission, and the county consultants for the careful and thorough review of our application. The detailed analysis and engagement throughout the process has helped us improve and strengthen the application before you all tonight. We are going to keep our remarks brief, although we know we'll have questions, and our team of technical experts are here to help answer those. We agree with the staff report and the proposed conditions. We do have 3 exceptions or clarifications. I guess I would call them slight tweaks to the conditions of approval, and we'll get to those too during our presentation. We can talk through that. And you'll see that we've taken steps to enhance the commitments to odor control, noise mitigation, groundwater protection, and environmental stewardship throughout the application. And we're prepared to continue to work closely with the county and the community to ensure these standards are upheld. It's important to note that this land use approval is just the beginning of the regulatory process. We've talked a little bit about it tonight already. And should the application be approved, the Oregon DEQ will conduct its own independent review before any further permits can be issued. In addition, the landfill will remain subject to ongoing compliance obligations, environmental monitoring, and operational oversight, both under state and local authorities, as well as the conditions of approval set before you all. And Republic Services are proud and live and work in this community and take seriously the role that we have to be long-term stewards of the environment. Thank you again for the time, for your thoughtful review and your consideration of the application. And with that, I'll turn it over to Jeff Condit to kind of to start to talk through some of the details around our application.
Thank you, Brian. Again, for the record, my name is Jeff Condit. I'm local counsel for the applicant. We are going to focus tonight on our responses to the previous staff report and testimony from the community that came in at the hearing and after the hearing. So we're going to be responding to those. As Brian mentioned, we overall agree. Oh, sorry.
It's on. Don.
Don, okay. Okay. Sorry, I was going to really be ashamed because I was instructed how to turn it on before I sat down. We agree with the analysis in the staff report and the conditions of approval with a couple exceptions that we will get to. Our focus has been on the key issues from the testimony, both the prior staff report and the testimony that came in from the community at the last hearing. We are going to focus our presentation tonight on sort of what we consider to be the biggies, which is odor, noise, groundwater, and I agree with the comment that groundwater encompasses all the water quality issues, fire, and litter generation. Those, just in our review of the public testimony, seem to rise to the top of neighbor concerns. And so, and of course, odor and noise were the 2 issues that we recommended denial on by the staff. We do have, as Brian mentioned, all of our technical consultants here tonight. And so if you have other questions about other parts of the staff report or conditions of approval, we have those people there for you to ask questions, but we're going to focus on those on our presentation to try to keep it as short as we can. With that, I am going to turn it over to Adam Jenkins of Greenbush to talk about noise. But before I do that, I'm going to mention to sort of just overview what's new. The biggest thing that's new about our odor study is our mitigation measures to try to bring those numbers down, and the proposed conditions of approval that relate to the imposition of those conditions. And I think I will now turn it over to Adam to talk about exactly what the analysis did and exactly what those conditions entail.
Thank you, Mr. Condit. Nice to be before you all again. Chair Fowler, Vice Chair Heyman, and the rest of the Planning Commission, appreciate the opportunity to chat with you again tonight. Since we last met, the applicant team has spent quite a bit of time reviewing not only comments from staff that were in the initial staff report, also questions and comment from you all during the initial hearing proceeding, and also the public testimony that was not only submitted that evening, but also subsequently. And we determined that if we could achieve a reduction in noise from the on-site equipment of 10 decibels, we would be able to reduce the increase to the existing quietest hour at the nearest noise-sensitive receptor to be not more than 6 decibels, which is a 5 decibel reduction below what we presented to you previously. And achieving this target would also reduce noise at all other noise-sensitive receptors to below existing conditions. Again, that quietest hour of existing ambient noise. Where our presentation a few months ago compared predicted sound levels to the median existing sound level based on input we got from staff in the initial staff report. That was one thing that they were concerned about. So we took that criteria and rolled it into our analysis. As a part of that analysis, the applicant proposed new measures, which includes testing equipment before the start of commercial services, the commercial service in the expansion area to verify that the sound levels are being achieved before commercial service commences. In addition to the pre-commercial service check, also performing weekly checks by Republic Services staff or Valley Landfill staff on site to verify that the equipment is continuing to operate. And if there's some sort of maintenance event that results in increases to sound levels of whatever piece of equipment that might be, there would be an opportunity for operations staff to address that before it may result in noise complaints. And these measures that were proposed and adopted as proposed or recommended conditions of approval, I should say, are in addition to the original recommendation and proposal by the applicant last time we met to update the noise study on a triennial basis every 3 years. These are additional conditions. Now, as far as the noise reduction goes, we can go to the next slide. How are we going to get there? How are we going to achieve 10 decibels of reduction in the on-site equipment? Well, we spent a lot of time coordinating with operations staff at Republic Services, which included coordination with equipment manufacturers to see what was feasible. Because it's important that whatever condition is put before the commission is in fact achievable, right? So we spent quite a bit of time on this, and the 3 factors or 3 tools, I'd say, that we believe will get us down the road of that 10 decibels of reduction include quieter equipment. When this expansion area becomes active, there will be new technologies that we don't see as prevalent currently, maybe electrical equipment, alternative fueled equipment that may have quieter sound levels. We want to be able to capture any reductions in equipment sound levels to that betterment and reduction of 10 decibels. So that is one factor. Another factor or another opportunity would be for us to install quieter mufflers. If the equipment itself doesn't get quieter by the time that the expansion area is ready to become commercially active, then muffler upgrades could be implemented. And this was validated with manufacturers. It's also possible that smaller pieces of equipment could be used that would generate quieter sound levels than what was the basis of our noise study prepared in 2023. And the third tool was to install noise barriers around stationary equipment, for example, at the tippers. Anything that's not going to move, a localized noise barrier we found to be much more effective than trying to erect a large wall at a property line near a receptor. Getting that wall near the activity we found to be much more effective. So through these measures, that provides the applicant with some flexibility when time comes to implement these. We're confident we'll be able to achieve a 10 decibel reduction of the equipment sound levels that were presented in the 2023 study, which will result in the offsite noise reductions we've discussed. The next slide. So the commitment, even though the previous proposal did comply with the state noise code, staff comments in the original staff report expressed a concern about the increases to existing noise conditions and stated a preference to reference the quietest ambient hour instead of the median hour for the existing sound level. This interpretation was a conservative and therefore highly protective interpretation of the state code. And the applicant has carried this recommendation into our updated analysis, acknowledging the opinion of the staff that this was an important criterion to satisfy. The updated application information and noise conditions in the supplemental staff report reflect the applicant's commitment to be a good neighbor and going above and beyond these legal standards for noise control, which is what our initial presentation a few months ago focused on. This commitment requires investment from the applicant, minimizing noise emissions. It also played an important role in shaping the layout of the proposed site plan as reflected in the application. The applicant's commitment is also a sustained one that will require regular noise checks and be able to adapt in response to complaints in order to minimize effects on the surrounding community. The updated conditions supported by the supplemental staff report, again, go above and beyond what's required by the state noise ordinance and ensure that the application satisfies CUP criteria and is compatible with the county code. I did want to touch on a question that Chair Fowler asked of staff during the previous portion of the meeting about enforcement and compliance. I think it's important for the commission to consider that even though the DEQ noise standards were used to assess noise effects, we're not relying on, the applicant's not relying on DEQ for enforcement. The enforcement mechanisms and the conditions that are included in the proposed conditions of approval require the regular monitoring of the applicant and reporting to county, and would not require a DEQ oversight for enforcement. That concludes the noise section. Thank you.
Thank you, Adam.
Do you want me to leave this one on or off? Thank you.
Is this better? Not better? Okay.
It's in the position.
Technology. So we're going to move on to odor management, which is the second of the biggies. What's new that is our sort of beefed up report. We changed the analysis to the bifurcated model as was discussed by staff. And we focused on 8 actual pollutants based on numbers. And we've come up with that constitutes our revised report. And then we've proposed mitigation measures in order to ensure ongoing compliance with that and enforcement and policing. So I am going to turn this one over to Ray Huff from SCS to sort of talk in more detail about how we addressed the concerns raised in the initial staff report and during the hearings.
Okay, I think this is on. Okay, I project loud. So good evening, commissioners. Thank you, Mr. Condit. I'm going to make it quick. I know you're going to have lots of questions, so I'll try and cover the large bases here. And that is, in response to the staff's original review of what we had put together, we actually expanded our air dispersion modeling. We actually included odor studies in the results of complaint logs that were provided to us. And what we were able to do is identify where are the complaints coming from? They're coming from the south, they're coming from the southwest. How does that match up with where everything's at on the site? So we looked at things such as what's the best way to mitigate odors? And you're going to hear later, it's going to be more gas collection. Gas isn't collected, it comes out of the surface of the landfill, it goes into the community. We want to avoid that, so you enhance your gas collection. But I believe there was a question in regard to proving the model. How do we best go about proving the model? Well, the good news is that's in the operating conditions. One of the operating conditions for implementation of the CUP is to conduct odor studies. Have personnel standing there looking for this magic D over T, and is it at 4? Is it above 4? Is it below 4? We're actually going to go and prove the model. That's the point of the operating conditions. And that's what we're going to do. So next slide. Thank you. So as Mr. Condit talked about, we used AirMod, which is approved by the EPA. It is the most valid model for something like this. And we went back and made, instead of one large landfill, We made 63 smaller little landfills and added them all together because we wanted to account for the differential topography of the site. So we did a whole bunch of modeling to make sure that we had it. And again, we focused on 8 pollutants that represent about 95% of the contaminants that we're seeing. So that's the best way to take a look at this. And again, all of our results are in the report that was provided to staff, and they agreed that it was a comprehensive and thorough report. So I can't wait for questions, but that is the quick version of the presentation. Thank you.
Okay, after the 5th try, I'm sure I'll have this right. So we are now going to move on to how we address litter. Again, litter came up in a number of comments and expressed concern about how we are currently handling it. So we have proposed some much more robust methods of controlling litter on site. And I am going to turn this over to Jeff Shepard to sort of talk about what those are and what the conditions of approval say.
Thank you, Jeff. Chairman Fowler, commissioners. We wanted to make sure that litter was controlled within the expansion area. We have proposed basically almost 4 levels of fencing. We want to have 2 layers of bull fencing, which is the metal fencing that you see in the slide. And then another fence, which is called a defender fence, which is about 12 foot high. And then a chain link fence completely around the expansion area. Next slide. And you can see from this slide that where we're proposing to put the fence would be a chain link fence around the expansion area. And the fence is in relation to OP 15, where we're proposing to fence just around the expansion area and not the entire site. And that would help with it would be more effective in catching windblown litter. It also would avoid litter encroachment on the forestry conservation areas, and it would reduce impacts to wildlife mitigation. And again, I think we have to note that there will be 4 levels of fencing to control litter in the expansion area. That is all I have. Jeff?
Thank you, Jeff. The other mitigation measure we proposed is expanding our litter collection activities to include Tampico and Soap Creek roads. Currently, we do 99 and Coffin Butte. So I'm going to turn it over. This is going to be our groundwater presentation. So we heard a lot of very technical information about groundwater, but the biggest concerns were whether or not the construction of the new site was going to reduce water levels in surrounding wells, whether it was going to have an impact on increasing arsenic levels, whether or not there would be increase in leachate releases, and talking about the levels of PFAS in the leachate. So I am going to turn it over now to John Hauer, who is our technical consultant from Geologic Associates.
Good evening, commissioners. I am John Hauer. I'm a geologist with Geologic Associates. I'm a new member of the consulting team. Today, I'm going to talk about 3 issues pertaining to water quality, water supply, and leachate chemistry. So getting into that, just want to set the stage. There really hasn't been a leachate release to groundwater at this site from a lined portion of the facility. So in the last 30 years, there's no evidence of a leachate release. The proposed expansion will only improve this condition because the new liner design incorporates more layers of impermeable liner, more leachate collection, capability, so it will improve an already very good condition at the site. We've seen a lot of comments associated with the presence of arsenic in groundwater at the site. And what we can tell you is that that is a naturally occurring condition associated with the levels of dissolved oxygen in the aquifer. Placement or construction of that new composite liner system will not change that condition in the expansion area. So we expect there to be no change in the arsenic levels in groundwater associated with the proposed expansion. Recognizing the community's concerns, Republic is prepared to comply with condition OF 13B to install sentry wells around the proposed expansion to incorporate them into the routine groundwater monitoring reporting network. And the current and future monitoring network that we do have at the site, in my opinion, is fully sufficient in protecting and safeguarding the water quality in the Willamette Basin. So moving on to water supply. The proposed development has a base grade elevation that's entirely similar to what we've already built on the north side of Coffin Butte Road. When we look at the impacts to water levels or the water table on the north side of the site as a result of the existing landfill operations, we just don't see a significant effect or change in the water table. We have the same geologic conditions on the south side of the site as on the north side of the site. We're going to have the same base grade elevation on the south side of the site. As a result, we don't expect there to be a significant change in water levels up gradient or in the community to the south of the proposed expansion area as a result of this development. We've conducted a simplified geologic or groundwater flow model to demonstrate that. What we're seeing is that the changes in the water level anticipated as a result of this proposed expansion will be the same thing we see seasonally with changes in the precipitation pattern. So about 3 to 5 feet here and there over time, with the effects tapering off about 3,000 feet south of the landfill. Now, we're not satisfied with that, so Republic has committed to a very detailed hydrogeologic investigation of the proposed expansion area that will help us design those sentry wells, figure out how deep they are, where exactly to put them, and to make sure that we incorporate them into the monitoring network to make sure that our assumptions on fracture interconnectivity are conservative and are protective of the community. One other item to note is that we looked at the effect of blasting on the fracture patterns, and what we found out is that blasting will only have a radius of impact of about 15 feet around each detonation hole. So that's not really enough to significantly change any of the transmissive nature of the water-bearing units at the site. In order to make sure that we are not affecting the community, Republic is prepared to implement condition OP 13A, which will include monitoring of those sentry wells, construction of additional sentry wells beyond those if we're seeing an effect, and even working with the community to monitor their wells in the event that we think that there's some effect that could be transmitted into the community. Lastly, I'd like to talk about the issue of leachate chemistry, which came up in a number of the comments. What we've done is we've looked at the PFAS and heavy metals results in the leachate at Coffin Butte Landfill, and how do those actually compare with other municipal solid waste landfills? And the result was they're very similar. Municipal solid waste landfill leachate is pretty much the same at Coffin Butte as we see throughout other landfills in the Western United States. There's nothing unique about it. And as a result, I think the way that the site is managing the leachate is appropriate. It goes to the wastewater treatment plant. It constitutes approximately 0.058% of the total volume of liquids that are treated at the plant. And according to the city's own records, there's no evidence of PFAS impact in their drinking water downstream of the wastewater treatment. So we think that, you know, we're not having a significant impact or any measurable impact on water quality associated with the leachate that's going to the treatment plant. Finally, there was an issue about the volume of leachate being generated in cell 1, which is the unlined, the very old cell that's part of the landfill. There was a concern that we were still generating 2 million gallons of leachate per year. In fact, over time, the leachate generation rate in cell 1 has decreased. This year, we're projecting to only generate about 1.2 million gallons, so far less than the asserted 2 million gallons. And we expect that to continue to decrease as the landfill continues its operation. So thank you for your time. Look forward to your questions.
Thank you, Ray. Now we're going to turn to fire. And what we have done since the hearing is we've addressed the public testimony by Adair Fire. We have agreed to improve reporting of fire incidents. We've corrected the record that there was a testimony the on-site truck doesn't work. It's working fine. And we clarified the type and number of fires in our consultant report and proposed some additional mitigation measures. So I'm going to turn it over to Jim Walsh of SES to discuss his updated report.
Thank you, Mr. Condit, and good evening, Mr. Chairman and Commission members. My name is Jim Walsh. I'm with SES Engineers. It's good to be with you again. I was the one, I've written 2 reports on this subject going back a total of 2 years. Thank you. And I was the one who provided testimony some 2 months ago before this group. Since that time, we have reviewed the comments that have come in from the public, both in writing and orally. I participated or I listened in on each one of the public comment periods, and I've listened to the comments that came from this commission and from staff. And we've identified 5 comment areas, 2 of which Mr. Condit just addressed, and I'll just briefly go through them and what our position is on each one of them. First is a comment from the Adair Fire Department with regard to the concerns that property tax revenue has not kept up with Adair Fire District growth and department responsibilities, potentially limiting response gaps in records and support of the landfill. This is news to us. I guess the Coffin Butte staff, along with a DSAC member, had a meeting with Adair Fire back in March of 2025. There was discussion about how the 2 parties have worked together very cooperatively for a number of years, a commitment by both parties to work cooperatively together on a go-forward basis. And it was on that basis that we felt like we'd have the support of Adair Fire going forward, and we're confident, we hope that we still have that. We very much appreciate the support we've had from the fire department in the past and hope that continues. There were some concerns about property tax diminution as a result of the landfill perhaps devaluing property, but the landfill has been around for a long time, this disposal site, some 70, 80 years, as a matter of fact. And so the impact on a go-forward basis shouldn't be a diminishment of property tax or valuations going forward. The next comment was with regard to a FEMA report, also from Adair Fire. FEMA wrote a report in 2001 that talked about the risk of fire coming from debris piles associated with their cleanup operations. And I'd point out that FEMA obviously has tremendous responsibilities with debris management, and in many cases they accumulate large piles of debris. And those piles can accumulate for a number of months, and they have the potential to start a fire. Sometimes when they're done with their cleanup activities, they remove the pile, or they have an emergency fire clearance to do that, or they may bury it. And sometimes that's called a landfill. That's not a modern municipal solid waste Subtitle D landfill like we have at Coffin Butte. And one observation was with regard to methane emissions, that there's a potential for methane in the landfill to contribute to fires. There's really no history of that at modern municipal solid waste landfills, so we don't see the connection. Next comment was with regard to Coffin Butte, recording fires and keeping incident logs of such fire events. Past history has been incomplete in that regard, but we're committed as one of the conditions of approval to keep a log of all fire incidents on a go-forward basis. And to provide copies of those reports both to DSAC and to Oregon DEQ. Next up is that a comment that was made before that an on-site water truck that's used for extinguishing grass fires does not work and is not functioning. That's just factually untrue. There is a functioning 4,000-gallon water truck. It's used for dust suppression. It's always filled and available for fire extinguishment, and it has been used on multiple occasions. And one of the conditions is that we'll make sure that we keep it in working order going forward. The last comment is with regard to Coffin Butte not properly representing the number of fires that have occurred at the landfill in the past, nor their magnitude. And my report identified 5 fires. That's not the number of landfill fires that has actually occurred at the landfill in the past. We'd agree in that regard. My report was only to identify significant fires that we thought and best represented the kinds of fires, mostly working face and grass fires that can and have occurred on occasion at the landfill. So, and those were meant to be representative. We think of working face fires, grass fires, and landfill gas extraction fires, which are the 3 types of fires that have occurred. With regard to the magnitude of the landfill fires that have occurred before, they've all been quite manageable in the past. There is one fire that is thought of a lot, and that's one from 1999. This is before Republic assumed operation of the landfill. My experience tells me that there must have been tens of acres of uncovered refuse for a fire of that magnitude to develop. And obviously, that does not occur now as we cover the waste every single day. And there's not the potential for a fire to be created and to expand at that size. Thank you for the opportunity to present. I look forward to your questions.
Well, maybe I'm wrong and that I'll learn how to use this by the end of my presentation. I am going to talk a little bit about the 3 conditions of approval where we would like some adjustments. We don't object to them wholeheartedly, but we think some clarification is in order. The first one involves maximum elevation. The proposed condition was that the final grade of the new landfill cell shall not exceed 450 feet above mean sea level and elevation. And what we had measured in our drawings was the top of the waste grade, so the maximum amount where waste would fill. There will be, as part of closure of the cell, a final 3-foot cover over the top. So that means the maximum height would be 453. So we're proposing a revised condition that the top of the waste grade will not exceed 450 feet above mean sea level, and the top of the final cover grade shall not exceed 453 feet above mean sea level and elevation. And we don't think, that's 3 feet is negligible and won't have any effect on the visual impact of the new cell, and it also will not create any additional odor impacts because the odor impacts are measured based upon the amount of waste. So that's just a minor little revision that we're suggesting. The other one is to operating condition number 14. This is working face. That one says that the applicant shall not deposit waste north of Coffin Butte Road during the development area's operation. Only one working face shall be operated at a time. That's a correct statement, but there is a transition period between moving from the north side to the south side, where we will have both sites open for a very limited amount of time, about 3 months maximum. And the reason for that, and we have Brent Lurch here from the environmental, who's the environmental manager who can talk to it. But typically what you want to do when a cell is first lined is bring in kind of softer garbage and line it with that before you bring in the heavy stuff like concrete and construction. And that just is an added layer of protection for the liner system. So that's why we do it. It's 3 months. So we've added a condition, we've added to that condition to say we can have a 3-month transition period for which we can move the trash from north to south. And that's not going to increase any volume, because what we're doing is diverting trips of municipal solid waste from the north side to the south side. So it'll be the same amount of trips. It'll just be both faces will be in operation for 3 months. So we have asked for that as well. And then finally, Jeff Shepard has already talked about this. This is in operating condition number 15, litter control, section E. Originally, staff asked us to build a chain link fence around the entire landfill, north and south, in order to protect against windblown waste. And our feeling about that is that's not going to be as effective. I mean, most of the windblown waste is generated from the working face. And so if you have that chain link fence around the working face area, which is what is shown in the slide that we presented, that will provide better protection. It will also have less of a visual impact. And we are also concerned that if you fence the entire landfill site, which is many more acres than that, that's going to affect wildlife migration across the forest conservation zone. So this would just fence the area around the working face and would provide that fourth layer that Jeff Shepard was talking about. So we've asked for that revision to that condition. And that is the end of our formal presentation. We have some additional slides there we've prepared in case of questions, but we're going to turn it back over to you, Mr. Chair, for any questions from the.
Very well. Thank you, Mr. Condit. And as with the revised staff report, we'll offer time to each of the planning commissioners for some questions, and then we'll have a round robin at the end. And just to vary things, we'll do it in reverse alphabetical order, starting with Commissioner Wilson.
Thank you, Chair Fowler, and thank you to the applicant in your presentation. I do have one quick question for our council. SB 726 was passed by the state legislature, which impacts the applicants. It may impact the applicant in regards to their emissions monitoring. And I just wanted to know if I can incorporate them in my question with regards to the odor. Okay. So I don't know how familiar you are with SB 726, which was enacted. And what I understand of the bill is that it's imposing a requirement on the owners of Valley Landfill and Republic Service to conduct ongoing emission monitoring. Do you see that as being complementary to on conditions of approval of the odor control, for lack of a better word, control of the landfill? Do you see that working complementary, or do you see that working just on the existing and not the expansion site?
Well, I'll give it the old college try. I have read the bill. The bill has been adopted. It requires a much greater level of monitoring. It requires DEQ to adopt some administrative rules and doesn't go into effect, I think, for 2 years. So with that proviso, what they will be using that for is taking that information into account when we have to go in and apply for our air quality permit for the new cell. So in the sense that it will provide better information about exactly what the levels of methane are, I think that will be overall helpful, but the devil is in the details with these new state laws. And we won't really know for sure how it's going to affect us until DEQ gets through the rulemaking process.
Okay, thank you. I'm going to move to noise. And my one quick question is, when, if anybody knows, was the last time there was active blasting at the existing site?
I'm going to direct that one to
Brent Lurch for Public Services. So
This summer, our spring summer, we currently are doing blasting activities.
Is that in cell 6 or?
Yeah, within cell 6.
Okay, so there's current blasting. And with regards to the water issue, you provide testimony that the effect of the blasting in the expansion area, I don't know, I assume is this the same for cell 6, that it's about a 15-foot radius and that there's no indication that the fracturing of the existing landscape changes the water flow in either the expansion site or the existing site?
Yes, that's correct.
Okay. And with the blasting as a noise issue, and with the removal of the material, as the water flows through that material that is being removed, are you monitoring for increased it was arsenic that I think that you testified before that is naturally occurring in the landscape, in the materials at the landfill. Is that correct?
Yeah, that's correct.
Okay. And do you anticipate any increased runoff from the blasting activity of that particular chemical or any other contaminants?
I would bring that more to John.
Yeah, so the arsenic concentrations are directly inversely proportional to the dissolved oxygen content. When you're talking about runoff, you're in a high oxygenated environment. You're not likely to increase the arsenic concentrations. With that said, we continue to monitor for it on a semi-annual basis, stormwater more frequently.
Thank you. And it's only because if I didn't read it correctly in one of your exhibits, well, in fact, let me just pull it up because I can find it. Oh yeah. Just for your reference, in Exhibit 47, this is where you're talking about the construction phase of the expansion zone. Just so that I have an understanding, when you're removing material from the expansion zone, you're going to move that across Coffin Butte Road to the existing site as cover material. And it talks about I'm assuming this is the total amount of material that would be removed from the expansion site. So I'm assuming that when you say 2.2 million cubic yards of material are going to be removed and potentially used for cover material at the existing landfill site, you're moving it by truck, obviously, to the other side of the road. And how long is that operation supposed to go on? Do you know?
Yeah, that's a good question. So with approval of this, we would begin excavation within the southern half of Coffin Butte Road. And we would use that for cover in kind of a stepwise approach, multiple years. So we're not just moving 2.2 million yards in a summer. We would slowly eat away at that so that by the time we are ready to finish up on, the north side of the road, we have a large majority of everything excavated. Then a contractor would finish up excavation, may stockpile some material south of the road for us to use for daily operations and daily cover south of the road. But yeah, the goal and thought behind it is it would be a multi-year process. So we're not, just going through 2.2 million yards in a summer.
Okay. I think that concludes my questions. Thank you, Chair Fowler.
Thank you, Commissioner Wilson. Commissioner Struthers.
Thank you, Chair. I think I have one question at the moment, and I'm trying to find the right way to ask this. So in your presentation, when you're talking about your groundwater response, there was mention of doing, one of the bullets is prior to development of expansion, a detailed hydrogeologic investigation will be conducted. And keeping with what I heard from staff tonight, they took a lot of your application and worked those into the conditional use of conditions of approval. Thank you. Would would you be open to adding essentially would be an 86 conditioned and having that as one of the, I believe it's the pre-phase or that phase before operations of the conditions, just trying to keep in line with what staff has been doing with that. So having that detailed hydraulic investigation done before operations conditions happen. Sorry, does that make sense?
I think I understand what
It
you're
doesn't make
saying.
sense in my head, but I know what I'm trying to ask.
Yeah, it would need to be done before operations. We would need to put in our monitoring wells before, and in order to understand where exactly those wells would be placed, how deep they would be, what the design of the wells would be, we would need to conduct that hydrogeologic investigation. So yeah, it would be a condition prior to development of the new excavation cell.
Mr. Struthers, I'd say if you want to condition it as a formal condition of approval, we would be open to that. It's, I think, a prerequisite for us doing the job the right way in the first place. So either way, it will take place that way. But if you feel more comfortable, or if there's more comfort associated with adding an 87th, then we'd be open to that.
Okay. Thanks, Commissioner Struthers. Commissioner Lee.
Thank you all. I have a lot of questions. I'll try to be rational here, but they're kind of not in any rational order. So there's a comment on staff report, page 55, that talks about construction activities are often not included as considerations for COAs. So then I look at noise on page 31, and I'm wondering if the modeling that was done regarding noise included noise from the blasting and all the activities during the construction phase. Did the noise modeling that you did include noise from during the construction phase?
I'm going to ask Adam to respond to that.
Thank you for the question, Commissioner Lee. Noise levels from construction were not specifically studied. Is a part of the noise analysis for application. I would like to point out that sound levels from blasting are regulated under DEQ or Oregon Administrative Rules 340, 035, 0035, sub 1, sub D, sub A. So there are some regulatory requirements that do establish thresholds for blasting, but no specific analysis of blasting or construction was completed.
What is the duration of the construction phase anticipated to be?
I would say it would happen seasonally in summer months from 6 to 8 months approximately, depending on weather.
So your construction phase is going to last 6 to 8 months?
Each one, it
How
will be
long will
done.
construction phase take, the whole construction? How many years will it take you to get to operational?
So we would build this out into different phases. So we would likely move the leachate ponds and entrance road in 1 year. And that would be 6 to 8 months in year one. Then the following year, we would build the portion of the southern expansion area, similar to, what we're doing in cell 6 right now, kind of putting those into smaller chunks. So in year one, we would build, a portion of the southern cell, and then likely the year after that, may skip a year depending on tonnage that comes in. If we have less tons, we might be able to skip a year, and we would finish that out. So you could say it would be likely 3 to 4 separate years, with each year having 6 to 8 months of construction.
So 3 to 4 years with 6 to 8 months of noise that includes the noise of the existing operation plus the construction.
Yes.
Okay. Okay. Regarding odor, on page 45, this is once again my confusion or the confusion over the intake rates. And my question, you know, you're talking about accepting 930,000 tons of organic waste. And so I believe you've said that you have a way to determine or distinguish organic versus inorganic waste. And so how is it going to work? I just still can't get my head around it, and I want to understand if you have essentially, it's not called a cap, but a limit of 930,000 plus or minus 10% of organic waste, but you can also take an unlimited amount of inorganic waste. Is that what I'm understanding? If the cap goes away in your franchise, this says you can take 930 plus tons of organic waste, but then the cap on inorganic waste essentially goes away. Do you have a way that you're sorting waste so this is going to be operationally functional for you? How does it really work on the land at the time?
Yeah, I would add a point of clarification that the current tonnage cap is at 1.1 million tons of municipal solid waste a year. That's how it currently stands. This new one would be that 930,000-ish tons of organic waste.
But the cap goes away according to the franchise agreement if we pass this expansion. So my question is then, the language in the staff report limits organic waste. It does not limit inorganic waste. So theoretically, what I'm trying to get at or understand is, in the future, if we pass this expansion, there will be an effective limit of 930,000 tons of organic waste, but no limit, because the cap goes away, to the inorganic waste. Am I understanding that correctly?
I would say it's acting as right now as it currently is. So with municipal solid waste would be an organic waste. So very similar to this. Currently right now, if we take non-municipal solid waste, we do not count that towards the tonnage cap.
So my understanding is correct then. Okay. Thank you. Okay. So, excuse me, I'm thinking here. Page 108 describes the forest conservation zoned tax lot 1200. It's the place where the gas to energy plant exists. That gas to energy plant will stay there, right? It's going to change, expand. You're talking about capturing more of the gases and methane. What's going to happen at that gas to energy plant?
Yeah, and if I could touch on the last question, I do want to say every truck that comes in, we do have a specific code to track that, you know, this truck has 15 tons of municipal solid waste. This truck has 2 tons of construction and demolition debris. I'm not sure if that helps clear it up, but we do track, you know, each truck bringing in each weight of 30 different subparts. To your question about what's going to happen to the landfill gas to energy facility, right now, PNGC is working on potentially upgrading that plant to an RNG facility. It's very infancy stages right now, so not a whole lot to go on that, but I believe that would cause a CUP for, you know, changing of that, and is kind of on their end to complete. As we as we continue to take more tons in, we will be generating more landfill gas. And to address that, we will build additional flares, upside or, max out our current one, and with conjunction with PNGC and us working to, take that landfill gas and have a beneficial reuse, that will also, we're always looking to expand that.
Thank you. Regarding the 4,000 gallon truck, so where do you get the water for that truck?
Is it on? Yeah. Okay. We get it from Adair Village. There's a filling station on Camp Adair Road. And so it's all, I mean, it's like drinking water.
Okay, great.
And the truck is brand new. It was we actually had an older truck that was taken to another facility, and that truck's, I think, less than 2 years old.
Thank you. So I'm looking at your statement that this truck is used in hot weather for dust suppression. So I'm looking at a hot day with the need for dust suppression and a hot day where there is a potential for fire. Is that truck kept full every day, or how is it actually operated?
Yeah, during the summer months, it's obviously kept full every day. During the winter, we don't need a lot of dust suppression. But in the summer months, it's ran every day. It not only covers Coffin Butte, but it covers Pacific Region compost as well. So it's constantly making routes around our facility.
That's great. But that means that there are times when it isn't really full as you're using it. Sure.
Yeah. But there's times it's also not more than about 5 minutes from where it needs to be. I mean, as the facilities are maybe a mile apart.
Right. Good, thank you. So I had a question that was left over from the prior hearing about mitigation wetland. And I wanted to get your feedback and comment. There, you have a mitigation wetland existing at the existing site, right? So there was a comment. So when asked about it, you talked about the requirements for a mitigation wetland. There was public testimony that the existing mitigation wetland is overgrown in invasive species and really not functioning as a mitigation wetland anymore. And I would like you to have the opportunity, since you haven't taken it in writing here tonight, to discuss that. What are the requirements that qualify a space that's listed on a map as a mitigation wetland? What are the requirements for that mitigation wetland?
Well, going back to the original core permit for that mitigation wetland, the previous owners had to monitor it for 5 years to ensure that the growth was there in the plants that they had planted. That was all done and submitted to the Corps of Engineers, and the Corps of Engineers sort of said, yep, it's good. And then it sort of acts on its own at that point. You could go in and do maintenance and remove the invasive species and things of that nature. But as far as the meeting the requirements of the core permit for the mitigation property, they were met.
Yes, so the requirements are met in the past, and in the present, if someone looked at it, it probably wouldn't meet those requirements. Is that what I'm understanding?
Not necessarily, no.
Okay. I'm sorry, I read this somewhere and I can't remember where, but it said that you have wetlands in the expansion area, and there are plans to mitigate those wetlands. And are you planning to do that in a separate space in the expansion area? I'm sorry if you...
The area that's impacted, the wetlands that are currently not part of the mitigation wetlands are going to be impacted by the new entrance. So mitigation efforts would either be off-site, i.e. towards down Soap Creek Road, at the intersection of Soap Creek and Coffin Butte. There's an area where the applicant could possibly do a mitigation area, or there's the opportunity to buy mitigation credits from a mitigation bank, but that bank has to occur in the same watershed that the wetland is being impacted.
Okay, thank you. So I asked this question at the last hearing, and now I'm confused again. You're using arsenic. You seem to be suggesting to use arsenic as an indicator of leachate leaking into the groundwater. And I guess what I'm hearing you're saying is you're talking about arsenic because the public talks about arsenic. And I'm wondering if it wouldn't make more sense to use a different compound to actually monitor for leachate leaks, because arsenic is already present in variable rates at variable times. So in my opinion, your condition of approval about arsenic and monitoring your new wells I wouldn't use arsenic. I would use maybe arsenic plus something else.
Yeah.
Does that make sense?
That's actually a really good question. And in fact, you're correct. Arsenic's not a great monitoring parameter for this site because it does occur naturally. And it goes into groundwater as a part of a natural condition. In fact, our monitoring program uses, I want to say, somewhere about 100 monitoring parameters when you include the suite of volatile organic compounds as well as the other heavy metals and the organic constituents. So we're looking at chloride, we're looking at nitrate, sulfate, bicarbonate, carbonate, 14 other trace metals, 47 VOCs every time we do the monitoring. Arsenic is a concern because it occurs at very high concentrations. Again, it occurs so naturally. But yeah, the presence of other monitoring parameters are better indicators of a leachate release than the presence of arsenic.
So I have a question about, again, I read it somewhere, I can't remember exactly where. You are proposing in the existing landfill, you have a open face, a working face of 1/2 acre. Is that correct?
It changes in geometry. It's anywhere from 1/2 acre to 2 acres.
So the new one, you've specified 2 acres. So I'm hoping that I'm asking an allowed question here. I understand you've asked for a new permit from DEQ to increase your methane emissions. Does that relate to this larger open working face, or is it unrelated?
I would say they're largely unrelated. The Title V permit is more about decomposition of waste throughout the entire mass and not just the 2 acres.
Okay. And I will ask this in an understanding you may not be able to answer it, but I would love to know the status of your Title V permit and the EPA investigations. Can anyone answer? I don't know what the answer, I don't have a clue what the status of each of those is.
Yeah. So regarding the EPA 114 letter, we submitted that to the EPA, have not heard back from them yet, which is pretty standard, with other 114 letters that we submit. It has a lot of data, so they're going through it right now, and we submitted it, gosh, maybe a month or 2 ago. So, it takes the amount of information that we submit to them it's going to take them some time to get through it all. Regarding the Title V permit, we are still working with ODEQ to get that finalized. One of the main things was when the original Title V permit was drafted, versus when we had the public hearing, there was a change to AP 42, which is an EPA standard. So as we did all the calculations, we're working with ODEQ to get everything drafted. We were working under the old AP 42 rules. As we got to public hearing and getting everything through there, EPA submitted revised plans to AP 42, and as part of public comment, ODEQ thought it would be appropriate, even though we are kind of on either fence of approval versus when everything was drafted and calculated. It would make more sense to go with the most recent revise. So we're working with them to get that completed, and hope to get that here soon.
So you don't have an up-to-date Title V permit from DEQ, is that correct?
We are still underneath the historic one.
And how long has that been?
We have, I believe we've submitted to get a new Title V permit 3 or 4 times. And the initial one was in the early 2010s, and continue to work with them to get that finalized.
I think that's all my questions. Thank you very much for your help.
Thank you, Commissioner Lee. Commissioner Fulford.
Thank you, Chairman Fowler. Have a couple of questions. I'll be pretty quick. I know it's getting late. Follow up on Commissioner Lee's comment, Brent. You talked about codes, truck codes on the organic waste thing. Curious about that one. Is that based on contract, or whose truck is getting filled, or do you guys actually inspect the trucks when you sign those codes?
Yeah, so it obviously a lot easier with our own trucks because we know, where they're going and can track those. As far as third party, yes, we do either a load inspection or, when somebody pulls up, question often gets asked what's in the back of your truck. So from there we can class it, whether it's, concrete or just trash that public is dropping off, whatever it is. So yeah, we look at that, assign it. We have probably 30 some odd different codes depending on whether it's contaminated soil, municipal solid waste, construction and demolition debris, sludge, whatever it is.
Okay, thank you. Question for Mr. Jenkins on you talked about testing of the gear, right, that works at the facility to figure out what was quieter. Can you tell me a little bit about what gear you actually tested and what those manufacturers were?
Yes, that information is included in our noise study that was dated 2023. Let me see if I can pull up a copy of that.
And as you're looking that up, what was the most, I think, loudest piece of, I suspect it's the engine, but that's the question.
The equipment that we measured sound levels for in our 2023 noise study is listed on table 5.3, which is PDF page 11. If you'd like to go look at it after this evening. Equipment included Caterpillar D9 dozer, Caterpillar D6 dozer, a Caterpillar 836G compactor, Columbia Industries tipper, a Caterpillar 330 excavator, idling trucks on the site, and trucks traveling uphill and trucks traveling downhill. Now, the noise reduction measures that are discussed in the proposed condition of approval are for on-site equipment only. So only equipment that is stationed at the site. So haul trucks coming in and out, private haul vehicles coming in and out wouldn't apply there. But for the dozers, the compactor, the tipper, the excavator, those would be the pieces of equipment that per the proposed condition of approval would need to be 10 decibels quieter than what's shown in table 5.3.
So follow up to that. I know Caterpillar has electric industrial. Are any of those numbers that you rattled off in that scope?
No, all of the measurements that were made that are part of the noise study that served as the basis of our analysis, none of those were electric or alternative vehicles. In fact, they were near the end of their service life. So we got a pretty
super noisy, right?
We got a louder sampling, yes. So we're anticipating that, as you mentioned, Commissioner Fulford, with the advancements of alternative fuel technologies and electric technologies, that those machines themselves may be quieter whenever the operations do move to the expansion area. So that's the main purpose of the first mitigation measure that I discussed. That's also mentioned in the proposed condition of approval, is to allow for the applicant to capture those reductions in noise. That if they're able to procure a piece of equipment that is 10 decibels quieter prior to the start of commercial service, they wouldn't then also have to do additional noise mitigation measures, but such as mufflers, which wouldn't exist for electric, or local noise barriers, but only if quieter equipment isn't available. Then they have those two additional measures, which would include the muffler upgrades, also potentially equipment shrouds. You asked about the distribution between noise from engine exhaust versus mechanical noise. It varies depending on the piece of equipment, but there are also other means to reduce noise available from the manufacturer besides the motor exhaust. It could all be considered as a part of those equipment upgrades.
Okay. And as far as testing, you didn't do any of the electric stuff, but you would do that in the future. How does that work? Yeah, go ahead.
It's a great question. So if the applicant were to procure electric equipment as replacing any of the number of the pieces of equipment that I mentioned, that equipment would be measured at the site prior to the start of commercial service to verify that the minimum 10 decibel reduction was achieved.
Okay.
So it will be studied at that, likely in preparation of that date, right? But it would be around that time that those measurements would be performed and validated. But I suspect those factors would be considered in the procurement plan for equipment as that date approaches.
Yeah, if you're shooting for 10 decibels less and you're getting a chunk that way, then let's do it, right? Thank you. I guess the next one's for John Howard. The hydrology and groundwater piece. Republic Services committed to performing a focused hydrogeologic investigation of proposed expansion area. When will this investigation begin? What specific methods will be used and will be made public?
I think I already answered this by saying that we would do it before the development of the expansion area. You need to do it in order to build the monitoring wells that we're proposing to do. So it's pretty much putting the cart before the horse, so to speak. So what would be involved? It would be drilling test holes, perhaps with temporary casings, perhaps doing some 72-hour aquifer tests to measure the response of water levels in adjacent wells so we can address the interconnectivity of the fractured groundwater system out there. Again, to better identify the effect or potential effect that the development of the expansion area might have on water supply wells in the community. Typically, that's what we're looking at, is just the overall movement of groundwater through the aquifer, and in this case, it's fractured bedrock.
All right, thank you. Chairman Fowler.
Thank you, Commissioner Fulford. Commissioner Cash.
Thank you, Chair. My first question is just that I did not hear something that was said. That gentleman in the blazer, you mentioned at the end, two leachate amounts that were in the millions, and I did not hear what you said. Could you repeat that, please? The very, very end of your presentation. That was you. No, you're right person. Yes, you.
Testing, 1, 2, there we go. I covered landfill fire risk. I didn't say anything about leachate.
Did you quote some millions amounts at the end of your, that was you? Okay, sorry.
Yeah, what I was referring to is there was a concern raised by the public that cell 1, which is the unlined part of the landfill, was still generating 2 million gallons of leachate per year. What I responded to that was that, in fact, leachate volumes have been decreasing over time. This year, we anticipate that the leachate is projecting to be about 1.2 million gallons, so far below that $2 million or 2 million gallon threshold that was referenced in the comment.
Thank you so much. PFAS measured downstream, not evidencing. Could you talk more about the data gathering, please? What did those communities do? Were there lots of them? Did they do a lot of testing?
The only information that we have about PFAS downstream is from the city of Corvallis. The only testing that we've done is of the leachate itself as it exists on site.
Mm-hmm.
So what we know is that we've transported leachate to the wastewater treatment facilities. They test their drinking water for PFAS, and they've had no detections of PFAS in the drinking water.
Thank you. So this odor monitoring that would take place perhaps in the future, what I took away from what was presented, I pictured 3 guys standing around at the landfill saying, trash doesn't stink, or trash does stink today. And I'm not trying to be sassy. I mean, that's actually the image I took away from what was described. Could you talk more about that? And when this monitoring is, we're using words like verified, do you go visit the neighbor's place to see if it's stinky over there?
That certainly is the potential. As written, what we're going to do is establish a network of survey locations, and we're going to have not just people standing around going, geez, does it smell? No, they're actually going to have these crazy looking things on their faces called olfactometers. And they are this device you hold up, and it's about this long, and it powers air into it. And what you do is you can rotate a dial, and what that does is change your dilution to threshold ratio. So all the way open, you're basically taking in fresh air, but then you ratchet it back and some of the air is filtered, and that tells you how diluted what you're smelling is. And just to make sure they're doing the right job, they're going to be trained using a host of, I call them, for lack of a better term, pens, but they are butyl pens that have different D to T values on them, and the staff will be individually trained on how to use them. Now, the verification part. What happens next is an independent third party comes in and they do a monitoring just to double check that there's no, yeah, it doesn't smell going on. That's what the third party verification is for. They have to get the same levels that the on-site staff is doing to validate the process for the staff.
And that's on a regular schedule, or is it when there are complaints?
It is on a regular schedule. And I can go, somebody has the condition in front of them, we can take a look, but yes, it is on a regular schedule.
And does that ever happen in off-site where the complainants reside, or?
My understanding is that is going to be part of it, but again, I'd want to look at the specific condition, but
Thank you.
sure.
Thank you, Chair.
Thank you, Commissioner Cash. Commissioner Bisco.
Thank you, Chair Fowler. Again, just testing you can hear me.
We can.
Very good. I have an assortment of questions that have really come out of a number of the questions that have been asked, and some of it is really leaning into just some clarification. So I'll start with Commissioner Cash's comments about the third-party analysis of odors. I too am curious about the scheduling of that. I know that the odor complaints that we've seen in the record and have been reported in the record aren't on a schedule, for example. That's not to say that scheduled, third-party analyses of these things won't be helpful, but they certainly are not likely to cover all of those instances where we have somebody else reporting concerns. So what does that look like when we have, one or two odor complaints that are happening that are outside of that schedule? Is that third party, are they showing up daily? Are they showing up on, on demand? What's the turnaround time? Odors, of course, change with the winds literally, and have appeared to be somewhat elusive in the analysis that we've been provided from the applicant. Any more detail that you have on that third party assurance, if you will, that odor concerns will be addressed, reported, mitigated, confirmed, those types of words.
Yeah, so as this condition of approval sits right now, that independent third party would verify at least once every 30 days. And then that would be documented and recorded. I guess as a monthly interval, seems fairly good as like a jump off point. And yeah, Commissioner Bisco, for the, times in between that month, I guess if there was, we could maybe do something where if, something, we got a call or something was verified or something like that. I'd have to lean on either the commission or somebody else on how we would maybe word that differently, or if we think that every 30 days is appropriate.
Okay, and I'll take that answer without, deliberating on what that might be. But just to clarify, then we're looking at once every 30 days, a third party is going to come in, and really they're not probably going to be doing the same testing for all those instances that may have been reported. They're going to be looking at a pattern of reporting, right? It's not likely they're going to be confirming an odor complaint at that time that they come in, more than just confirming that the process is occurring in-house, correct?
Yeah, they would do the testing, and if I guess if we were to find some a variance from the all the different stations are meant to encompass kind of 360 degrees, but if we needed to alter that for some reason, I think that would show in the data.
Okay. Another point of clarification. So I'd like to go to the on-site truck. If you can just confirm again, I thought I heard 4,000 gallons of water is on site in that vehicle, correct? And I'm sorry, I don't know the names of everybody that's here on staff. It's just a little hard remotely, so my apologies. I'm not sure who to ask that question to.
Yeah, I can verify. Yes, 4,000 gallons is correct.
Okay. And is that a normal kind of a fire engine type 4,000 gallon water tanker, or is that a special piece of equipment in the landfill industry?
That's a good question. I would say that's a fairly standard size.
Okay.
Yeah.
And with that, oh, is there somebody else that was looking to comment there?
It sprays out the front and the back, and it has a hose, and you could use it to spray in a specific spot.
Okay, so to be clear, this is not a fire, water truck. It's not got a pounds per square inch that we're managing, for example. Is that when we say spray, are we talking a normal hose, not a fire hose?
More than a normal hose, but maybe less than a fire hose.
Okay. And with that, for the capacity that it has to pump out water, how long is that 4,000 gallons good for in the case of us more than average, small grass fire or something that just started that's the size of a wheelbarrow or, a tractor bucket, for example?
Well, I don't think that the truck is meant to be the only means of fire suppression. We, use the truck to control, and also we use heavy equipment. We use our cats, our compactors to push dirt. And then as any, normal situation, if it was something that we couldn't handle, then we would call a dare. But again, it's not meant to be the end all of be all. It's one tool of many tools that we use.
Okay, that's helpful. To the point of methane-related fire events, just looking for some clarification. So I heard that when we talked about in the prior application, that we were talking about kind of 5 general types of events, not a specific number of events, if I remember that correctly. Also asking the question then of, I heard that methane gas fires historically, I don't think inaccurate was the word, but not happening is kind of how I interpreted it. But in the same kind of sets of comments, I also heard that you do look at methane related fires. Yes or no? Are we talking about, I hear that there, in one sentence I'm hearing that there wasn't really any consideration given to that. In another sentence, I'm hearing that that was, one of the scenarios that you've looked at as far as fire suppression. Can you clarify that, please?
Sure. First, with regard to the numbers, there were 5 specific fires that were cited in our report, and they were
Yes.
not meant to be a complete listing of all landfill fires that have occurred at Coffin Butte over any given period of time. They were meant to be more memorable, perhaps bigger, and representative of the kinds of fires that have occurred out there. There have been more than 5. Then we identified 3 types, 3 general classifications that we think are all encompassing of the kinds of fires that happen at any landfill, including Coffin Butte. And those fires were working face fires, which are more prevalent than the other 2. The second are grass fires. They have occurred as well at Coffin Butte. And the third type of fire that can occur is an overdrawn gas extraction well that induces oxygen down the sidewall of the well and creates spontaneous combustion and can create a fire. There's no record of any of that latter category having occurred at the site. And then, Commissioner, could you remind me of the second part of your question, please?
Actually, no, I think you might have answered it. You helped now, and I found my notes on that too, because it was what you were saying of no history of that in, I have it written down as modern landfills. So just to clarify, because methane, the explosivity of methane gas, and the concern over fires was such a recurring theme with some of our testimony. I just want to be very clear on where you're at with this. So a spontaneous combustion fire on that overdrawn gas extraction well scenario, has that happened in other landfills? Not at this site, I hear you now saying. So thank you for that clarification, but has that happened in other landfill instances?
Yes, it has happened. And just a point of reference, the Clean Air Act New Source Performance Standards for municipal solid waste landfills, one of the aspects they look at very carefully is the temperature at the wellhead of a gas extraction well. And that temperature is monitored specifically to see if temperatures are rising as a result of rising temperatures headed towards a possible spontaneous combustion. So there is monitoring that's performed monthly to observe whether the well is operating properly and not being overdrawn and not developing a symptom associated with that.
Okay, and that was part of the Clean Air Act, you said, right?
Yes.
Clean Air
Right,
Act standards. And is that
that's correct.
monitoring done by then the EPA, or is that monitoring done by the landfill and your staff?
In this case, it's done by an outside contractor that mobilizes the site every month to check every well.
Okay, and that's occurring at Coffin Butte then?
Absolutely.
Okay, very good. That's very helpful. from that topic then, I do have just a point of clarification. I wasn't sure, and it was about Adair Fire District and also the Coffin Butte folks meeting with a member of DSAC. I wasn't clear, was that and it wasn't recent. I'm sorry, I don't have the time right here up in front of me, my notes. It wasn't a recent meeting. Was that a public meeting? Was that some other, and it goes to, you'd mentioned the point of continuing to collaborate with DSAC at the county.
Yeah, this is Brett Davis. So yeah, I think how it started was through DSAC. One of the members, geez, remind me of his name. Yeah, David Hackelman, who's a property owner to the north, had requested that we get together and talk about just the neighbors' concerns, and so. So your question on it, was it a public meeting? I mean, it was public in that we had the Adair Fire Chief and another member of the Adair Fire Department, myself, Bailey Payne, Julie Jackson, and Mr. Hackelman and Paul Coster. And so it was just a conversation about what are the real concerns here. And what we got out of that meeting was that we, I felt we walked away. I provided a summary as Mr. Hackelman did, but we walked away with Adair saying that they had always partnered well with our team and our operations manager. We did have to clarify some information as far as, there had been some changes with Ian McNabb leaving and Paul coming on, so we had to update some emergency contact information. Made sure that they had all the access to all of our gates, and we gave them full permission that if they ever have to show up and they have to cut a chain, just to cut the chain. We're not worried about that. And they were very cooperative. We were cooperative. But ultimately what it came down to was the concern during fire season and specifically like red flag days when the temperatures are just perfect and the winds are just perfect, where we've got, low humidity and a high fire risk. And the concern was, or the question to us was, are we willing to have some after hours fire watch, when operations is gone, just to make sure that nothing flares up. And so we walked away with some things, and we committed to meeting more regularly, which I'll admit we need to get some things on the schedule to meet, like probably quarterly, but it was a great conversation, and that's how we walked away.
Okay, that's helpful, and I appreciate that kind of anecdotal, not in your application, but it does show to that cooperation with your regional partners. I am going to circle back to my 4,000 gallon the water truck. In the event of a gas well fire, the fire truck, the water is not an effective, is it, suppression for a gas fire? Just for clarification.
Typically in those scenarios, what you would want to do is generally use soil to smother that area, and then also, look at surrounding wells within that area and cut off vacuums so that you're not stopping the spread of that.
Yeah.
Could be an instance where water would be helpful, but in that instance, the best option would be soil and to cut off vacuum from around that area, or pulling it, further into the waste mass.
Okay. And in that case, big equipment, your cats and such, do they have access to all of those gas wells?
Yes, and definitely in the sense of a fire, we would make sure that, either an excavator or a dozer could get to that, and that is possible.
Okay. Let's see here. Just confirmation. So this was a question I had, and Commissioner Lee asked this question about the length of construction. Couple questions here, actually. So the construction, now we've confirmed, could be as much as, rough estimate of maybe 32 months over a course of up to 4 years. So up to 6 months, up to 3 times, I think is how I heard it. Is that correct?
Yeah, generally speaking, I mean, that we would need to go through, getting everything approved by Oregon DEQ first to kind of, that would be the next step in this process to really get that figured out. But just trying to set, the goalpost, that is what will likely happen. Yeah.
Okay, and in that development process, that's going to occur simultaneously as the operations on the operating phase of the landfill. Um, like everything I see is that's what we're talking about. We still have an operational landfill, and we're going to be developing this new expansion location. So those two things will be happening simultaneously, correct? Although maybe intermittently, but they will be happening concurrently.
Yes, at least for getting the ponds and then doing that first subsection of the southern area. As we expand more into the southern area, we would have full operations to the south. So
Okay,
they would overlap.
they would overlap. So with that, was the road the road litter, the trucking? I hear that the odor was not odor. Noise was not considered in the construction portion of this process. Is the truck traffic, was that considered in the traffic analysis update?
Good evening, Commissioner. For the record, Joe Bestman, Transite Consulting. So the
Thank
traffic
you.
study looked at the impact of operating the current or the former Knife River quarry site along with the landfill. And so we think it'd be about the same intensity having this ongoing, effectively a quarry site and a landfill. So it's accounted for, but it wasn't directly accounted for because we didn't know those specific timelines and all the details about where exactly these construction activities might occur.
Okay, and that's a fair consideration. Cell 6 then is where Knife River's been working in that quarry. Can you give me a rough estimate, someone in the room, of the acreage of that cell 6 that we're talking about as compared to this expansion location?
Yeah, cell 6 is approximately 25 acres. And let me flip to the page. Yeah, the southern area in total would be about 41.5 acres. But yeah, we wouldn't, as I was saying, how we would sparse it out into multiple years. That 41.5 would likely be subsectioned out into 8 to 10 acres each time.
Okay. Again, helpful. And then just to clarify, cell 6 is sitting on that northerly end of the current operations. Are there buffer lands just to the outside of that, the north side of that, or across the road there? Or is that residential in the same way that the southern expansion area is more surrounded by residential? Is that similar?
That is, I believe that is in buffer land. It is a permitted footprint with ODEQ, so
Right.
it has passed all local siting approvals.
Yeah, that's helpful. That my question really was, what's the residential profile look like around that northern footprint there where Knife River's been operating?
Yeah, there might be a handful of houses around that area. I would have to get back to you on that, but it's not there. There aren't really neighborhoods in that area.
Okay, thank you. Another question was the impact of the blasting. What I believe I heard was that we were looking at approximate 15 foot. Is that the concussion impact? Is that the fracture impact and the basalt? When we say 15 feet, which is the number I recall hearing, what are we actually meaning by that? Is it water related only? Is it risk related? And what kind of equipment is only a 15-foot blasting impact, I guess would be another question.
Yeah, the 15 feet is related to the fracturing associated with the blasting. So that's a radius surrounding the borehole used to detonate the explosive.
Okay, and not related. So is there any variation in that where, oops, gosh, it went a little further than 15 feet because we thought it was a basalt ridge and maybe there's a fluctuation in that?
Sure,
How do you manage risk, I guess, in this space?
that's the higher end value given to us by the mining experts based on the geology of the site. So they quoted a range from 3 to 15 feet. So we use the 15-foot as a conservative estimate of the area of impact.
Okay. And then as I heard you, and again, because this came up quite frequently in testimony, was the risk to local groundwater wells there. The after the blasting period, then you will be analyzing that impact and footprint, and that will all kind of come into play with that groundwater testing, where you're going to set those groundwater well testing sites. Is that part of that process? Or, what's that after we blasted, we stop and we take a look around and see what we've done. What's the impact?
So
And
we will have already built the groundwater monitoring wells at that point. And we will be monitoring them, at the frequency agreed upon by DEQ, probably semi-annually or thereabouts. And if we see an effect in the groundwater monitoring network associated with the blasting, then we'll evaluate that and take appropriate steps, whether that's changing the wells or putting in new wells. But we don't anticipate that's going to happen based on the blast radius. We're not going to be that close to where they're blasting for that probability to be very high.
Okay. And then I think my last questions center around really the landfill liner conversation. We have an existing landfill that has existing impacts that are recognized in this process, we'll just say. Certainly there's a fair amount of testimony of concerns of those impacts, and expansion will expand those impacts, not all of them, but some of them. And this goes to the liners specifically. So cell 1, I believe, and cell 1A are unlined. You mentioned them this evening. A member of your team mentioned that, 2 million gallons were reported in the testimony, but correcting that back to 1.1 million, which is still a lot of gallons of leachate, no matter how you look at it. But I want to go to the point of, could you explain, there's no liners in this, in cell 1 and cell 1A. What is the material used for the collection of leachate, for example, in cell 1 and cell 1A? And it does go to every cell, but in this case, this is one that doesn't happen to be lined, but we are managing some measure of leachate and documenting it. How are we collecting that?
Yeah, so as part of that, sumps were installed to collect that. Looking at how, I believe both of them are clay line. They're not subtitle D. So we do have sumps that are extracting that leachate within the waste mass. So that, and then it gets pumped to our pond. So that's the difference where, the more modern, I guess, our new, double liner system that we have for subsequent cells have leak detection and some other items with that.
Okay, and again, because this is an ongoing concern, let's go to those more modern, the double liner system, for example. What's that leak detection mechanism look like? Like, let's take cell 2, for example. Can you just hip shot the size so we're talking a familiar size? How many acres is cell 2? And what does that liner system or that leachate detection system look like?
Yeah, off the top of my head, I can't comment on acreage of cell 2. I would imagine it's somewhere in the ballpark of 20-ish acres. But it has 12 inches of gravel and then a perforated pipe on the lowest portion or the yeah, lowest portion of it. And then there's a standpipe that comes up that we can extract a leak if it were to occur, or we can also verify that there's no liquid within that rock and perforated pipe section.
Okay, so is the liner then under that rock? Just so I understand, right? Water would go through rock, which is porous theoretically. So is the liner theoretically catching that leachate?
Yep, yeah, it's liner, that rock and pipe section, liner, and then another rock section, and then waste.
Okay, and I, for those that didn't go on the landfill tour, I do remember that, and I appreciate the refresh because again, this is coming up in testimony. So on that 20 acres, approximately, how many pipes do you have that might detect a leak?
So for cell 2, I believe we call it like V-shaped or herringbone. So everything, whatever on this side goes to one pipe, and then on this side it kind of drains towards one local pipe in, but it's graded on the base, so everything would fall to that lowest point.
Okay. And then just to clarify then, this is what we have in existence from not cell 1 and cell 1A, but cell 2 moving into what will be cell 6, correct? It's the same model.
Yes, yep,
Okay.
all of them are similar.
And the expansion, will it be the same technology?
Yep.
Okay. I applaud you for the complexity of that process, and I know that efforts had been made here. I'm going to just ask for this question. In the industry, what we've heard in testimony is that liners will fail. Eventually, they will fail. Is that correct?
Yeah, I don't think I've seen any conclusive evidence that shows that. Pre-subtitle D, I think there has been some, but with, subtitle D, and use of synthetics, I don't, unless a puncture has happened, there hasn't been any failure.
Okay. And so in the industry, then we can confirm that liners do not fail, that they have a lifetime that ensures that we don't have that leakage, which is again that risk factor that continues to kind of percolate up in testimony.
Correct. Yeah. And like I said, unless, something injured or punctured that liner.
Sure. So conditional. Okay, that's helpful. And then just to clarify the leachate, I was unaware. It sounds like what I heard anyhow is that there is no PFAS showing up in Corvallis's leachate that's being treated. Has Corvallis updated to treat PFAS at their water treatment plant? I was not aware of that, so
No, I believe that is data found from Corvallis's drinking water.
okay, so not from the effluent, from the treated leachate, just in the drinking water, correct?
Correct.
Okay, and do you know then what mechanism they're using to treat for PFAS? Because my understanding is most municipalities do not have, including Corvallis, do not have the capability to remove PFAS. Just check.
Commissioner Bisco, I'd suggest that's a question outside the domain expertise of
Okay.
the applicant.
Okay. Thank you, Chair Fowler. I'm just trying to clarify the statement that was made. So that's the last question I have then. Thank you. Thank you.
Thank you, Commissioner Bisco. Vice Chair Hayman.
I have no additional questions.
Thank you. I just wanted to follow up on my question of the staff report in terms of trying to validate and verify the odor model. And if we know the amount of organic debris going into an existing landfill site now, we have a model, we have measurement of odor. Does the model get verified with empirical data with operations today? I would guess that's a Mr. Hoff question.
Yeah, I'm certainly, can you guys hear me? Certainly happy to give it a try, but my good friend Greg is here too. As far as the model goes, we use the empirical data that the site has, that they're looking at their waste profile and what it is that they have, and that's what we used. Like we said, we used the 2023 values that they had for tonnage, and that was the amount of organics that they had. So that is the empirical data. We didn't theorize the amount that would come in. We actually took measured values.
Thank you.
Sure.
Now open it to the final round of round robin questions. Commissioner Struthers.
I will make it quick. I never thought I would be asking about a water truck related to a landfill, but I'm going to follow up on a question. It's sort of came from Commissioner Lee, and sort of building off of one of her questions, I believe. Is the water truck considered sort of like a fire tender water truck? No. And the reason I'm asking is because what I heard was when it needs to get filled up, it goes into their village, so offsite to get water. For say lo and behold, there is an emergency at the landfill. Are there sirens or lights on the water truck so it can get back in a hurry? Like an emergency vehicle would happen. Okay. I just want to make sure from this. I was just curious, just from listening from the discussion of what we were having here. My last question actually goes back to Commissioner Cash and Commissioner Bisco, related to related to water and PFAS. I heard that that Corvallis tests their drinking water and there's no PFAS in that. And understanding that would happen because of where their drinking water comes from, both upstream on the Lamp River and then the Rock Creek watershed up on Mary's Peak. So it's coming from a different source away from the landfill. But was there any testing or information provided by their village related to PFAS testing?
I can't confirm that, but we have had conversations with Pat Hare, and he has told us that they have no issues with the drinking water quality that's taken from the Willamette River.
Okay, thank you.
Commissioner Lee.
Thank you. I'll try to be brief also. Regarding leachate, your contract with City of Corvallis ends at the end of this year. I'm looking for information about scenarios for that termination of that contract. Do you have a replacement contract?
We have identified a couple outside sources to potentially take that loss in City of Corvallis and continue to look around the area as well. But I think the important thing to note is regarding this expansion or not, we will have to handle our leachate till the close of this landfill, and then 30 plus years into post closure.
Thank you. When I'm looking at a scenario in which you don't have a place to take the leachate for treatment, potentially during a rainy season, and you might have to store it and your leachate ponds get full. What is there? Is that a reasonable scenario? Is that a concern?
Somewhat of a concern, but we can't have our leachate ponds over top. So we would have to find a disposal outlet for that.
Thank you. Regarding fire, so the past questions led me to try to remember, wasn't there a fire? On the forest conservation land, there is a gas to energy plant. Weren't there 2 fires at that gas to energy plant?
They were both grass fires due to the open flame. It was during farm season when those fields had been cut, and we believe some wind went up and the grass got ignited by the flame. But those both of those burners are gone, and we have an enclosed flame now, so that's not possible to happen because the flame is inside.
Thank you. Okay. So I didn't spend a lot of time on the conditions of approval, because I thought we would be discussing them a lot next on the 22nd. But and now I'm seeing that there have been lots of questions about them. So I'll ask one specific question. Why is BCC Title 31 only for operating operations and not for the preliminary steps? Page 145 or 141. No, wait. Yeah, 141 starts the preliminary conditions of approval. Page 145, operational conditions of approval. Monitoring of operational COAs will be subject to BCC Title 31 enforcement. But that suggests to me that apparently preliminary conditions of approval would not be subject to Title 31.
Maybe we can address that to the planning staff. Commissioner Lee, if you could ask your question again. I believe it's a question most appropriate to planning staff.
Oh, thank you. I'm sorry. Did you hear my question, Petra? Oh, certainly. On page 145, for operational conditions of approval, it refers to monitoring of operating COAs being subject to BCC Title 31 enforcement. That suggests to me that preliminary conditions of approval would not be subject to Title 31. Is that true?
Yes.
Okay. Thank you. I guess I won't ask any more questions tonight.
I'm looking back and forth, seeing no questions. So I will thank the applicant for your revised presentation and all the answers to our many questions. As predicted, we have gone late, and I would expect that, oh, Commissioner Bisco, do you have your hand is up? Do you have a question? Is Commissioner Bisco on mute?
Oops, can you hear me? There we
Now
go.
yes, we can.
Okay, sorry about that. Just one question related to the 900,000 ton limit, not tonnage cap, but the limit on organic waste. I heard something in the applicant's testimony that made me wonder, how do we define organic waste versus non-organic waste for the purposes of this application?
Yeah, I would kind of go towards regulations either through the EP or likely EPA and just say that it would be a protrusible waste or a waste that's, decomposable.
And so
Perhaps I would paraphrase, anticipating perhaps what Commissioner Bisco's question is: organic waste synonymous with municipal waste? Roughly.
I would say organic waste is the big circle, municipal solid waste is a smaller circle within that.
And Commissioner Bisco, does that get to your question?
I think it largely does get to my question. That doesn't address like natural materials, things that maybe they're going to our compostable sites. But when we talk about timbers and wood materials, are they not? Do they not also decompose and potentially create methane in an anaerobic environment?
That would be considered an organic waste, but large majority of that is composted.
Okay. And yes, Chair Fowler, that did help get to my question. Thank you. But that's all I have.
Very well. So again, thank you to the applicant and all of the experts. Thank you to the planning staff and their experts. We went long this evening. I anticipate we'll go long again tomorrow evening in order to get all of the public testimony on record. But with that having been said, without objection, we are in recess until tomorrow at 6 p.m.